from some unauthorized sources.
Somebody is giving you a lot of money.
27, yeah, 3 crores rupees already remitted. My lordship.
Monday.
And
Tahsildar has issued the endorsement.
You said that thrice.
Walk to the door of the temple, my lord, or otherwise my writ will become infructuous. 230, my lord.
It won't reach. That much we are telling you. After we finish the list, only 230. People who have been listed should not be deprived.
Please.
This 230 thing will deprive other people whose matters are listed. You can't take a shortcut into the thing. Sure.
Adjournments, page number 9, serial number 72 and 73.
My lord, serial number 72, my lord.
Yes. Yes.
My lord, serial number 72 has to be posted before a different bench, my lord.
Why?
My lord, the parties, if I'm not wrong, this is a conflict.
You'll see when the file comes. What is it that you're submitting?
No, my lord, it has to be placed before a different bench.
Why, madam?
My lord, there's a conflict with the petitioner.
Then you should make that submission.
Yes, my lord.
Place it before different benches and artha another.
I apologize.
Is placed before a bench of which SGRJ is not a party.
Wait, my lord.
Serial number 73, my lord.
Hmm.
I appear for the petitioner. I'm led by Senior Counsel Mr. Srinivas Raghavan. It's unavailable today. It may be listed on 29th, my lords. I've informed the
Request of counsel for the petitioner relist on 12th November.
29th.
Sorry. Next.
Page number 10, serial number 74 to 79.
My lord, serial number 78, my lords. We are awaiting instructions, so short date may be given, my
What are you
lords.
for?
I'm from respondent 2 and 3, my lords. I've informed the other side as well.
Any objections? We fix dates and everything. What date, don't ask. At the request of counsel for?
Respondent number 2 and 3, my lords.
For number 2 and 3, relist on 12th November.
Page number 11, serial number 80 to 84.
In this case, a week's time may be granted you.
At the request of counsel for the petition 11th November.
Published.
Page number 12, serial number 85 to 91.
Serial number 87.
Yadu? 90. At the request of counsel for the petition 11th November. Yes.
Page number
Serial
13.
number 87. Respondent 1 and 2. Respondent 4 and 5. 6 1 week time.
Inform madidira?
Inform ಮಾಡಿದ್ವಿ.
At the request of counsel for respondent 4 and 5, 11th November.
Page number 13, serial number 92 to 98. Page number 14, serial number 99 to 104. Page number 15, serial number 105 to 1110.
My lords, serial number 108, my lords, for the petitioner.
Yes.
Pray for a week's time, my lords. I've been
The request
informed the
is-
other side, my lord.
You are informed?
Yes.
The request of counsel for the petitioner relist on 11th November. IA 1 or 25 is allowed. Production of so and so is dispensed with.
Interim order may kindly be extended.
Order earlier granted is extended till next date.
Highly obliged.
Number one.
Your lordship, on submission, your lordship. List number 2, serial number 6, your lordship. This matter, MP Srikanth is appearing in this matter, your lordship. Srikanth sir.
Number 2, serial number 6.
6, your lordship.
6 sir, Puttraju ಇದೆ.
ಅದರಲ್ಲಿ ಶ್ರೀಕಾಂತ್ ಸರ್ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಶ್ರೀಕಾಂತ್ ಅವ್ರ ಹೆಸರು ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, ಅವರಿಗೆ ಎಂಗೇಜ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಪಿಯರ್ ಆಗೋದಕ್ಕೆ. ಅವ್ರ ಮದರ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ. ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಆಫ್ಟರ್ 3 ವೀಕ್ಸ್ ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
ಹೌದು ಸ್ವಾಮಿ. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ ಅದರ್ ಸೈಡ್ ಅವ್ರಿಗೆ.
Yes, my lord, already.
At the request of, you are there for that?
No.
At the request of, it's submitted that there is a bereavement in the family of the arguing counsel. Relist on 19th November.
Much obliged.
Serial number 19, after 10 days of a time.
19, wait.
Your lordship, may please to reserve the matter regarding PTCL, my lords.
Yes.
There are 2 subsequent developments, my lords. No, not for listing the matter, my lords.
No, if there is anything, then in the presence of everybody.
That would be right, my lords. Then,
Presence of everybody.
your lordship, may I'll inform everybody for mentioning on 23rd, my lords, on 20. The only thing, only reason is Nikanti court has asked for open court hearing in the Nikanti itself, my lords.
2017.
Supreme Court has started.
Yes, just to inform, just to We've state filed appeal, my lords, court has, they only not to argue the matter, my lords, just to point out this is, and the other judgment, my lords, court has, which followed Honorable Justice Dixit's judgment in that, following that notice has been issued in the other matters, my lords. So just to bring it to your lordship, as your lordship
Move
said.
a memo in, let
I'll
whatever
give
they
a serve a
want to
copy
say.
on them and mention the memo, and I'll just, along with the memo, I'll just.
This has become a never ending story. Some memo or something is happening.
Well, in fact, there are poor people now, they're pursuing their rights. And luckily, my lords.
ಎಲ್ಲ ಕಡೆ ಅದೇ some problem, both sides will have problem.
Anyway,
you
that,
move a memo.
in fact, my lords, to undo Nikanti, this has been done. This is independent of that because their whole case is only Nikanti, my lord. Anyway, I'll make my submission when they're there.
Now what to do with this?
No, your lordship may go ahead. That is independent of this, my lord. Just to, because. Just to bring to your lordship, that has nothing bearing on, because this is under Nikanti, even assuming.
Move a memo, 23rd.
Along this and one more order, Supreme Court orders, they both I'll
Place both of them.
along with them on Monday, on Thursday.
Thursday.
My lords, serial number 119, my lord. Senior is on the way from Dharwad today.
119.
Yes, 10 days of time. We are furnished
So we are
some
from
judgments.
Dharwad, he'll reach by afternoon. don't
Afternoon, but we have to produce some judgments. I have two submissions.
ಹಂಗೆ ಹೇಳಿ ಮತ್ತೆ.
One is
Have
inconvenience.
you informed Mr. Sampath?
Sir is informed, my lord.
119 at the request of counsel for respond number 1 and 2. Relist on. 11th, 10th November.
Deeply obliged.
List number 1, pronouncement of order, serial number 1, Sirajuddin Ahmad.
Petition.
Madam, in this we have directed, you can go through it after it being released. You'll have to inform the ACS Home, Director General Prisons and Correction and DGP IT, so that some system could be done for this.
For receiving the applications through
Receiving the
email.
application online, processing it, getting the application, developing a format for that report.
Yes, ma'am.
ಸುಮ್ನೆ submit a report ಅಂದ್ರೆ ಹಿಂಗಾಯ್ತು.
They are receiving the applications through mail also, my lord. Though any family member of the convict, my lord, if they send any mail, my lord.
No, you develop a portal.
Yes, ma'am.
So that application ಅಲ್ಲಿ in reason ಎಲ್ಲ what are the, what you finally say is something which they have to say is not said anta. So if you make a column for it, they will mention that.
The procedure what is followed is, my lord, the applicant has to file an application in the form 9 and 11, my lord, according to the parole they are seeking. What they do is that, my lord, whenever they receive any application through email by any of the family members, my lord, then they will call that particular convict, my lord, and get that application filled, my lord, and get the signature of the convict, and then they will process that application, my lord. That is the procedure that now they are following, my lord.
So that they
They
can
will put
give
it
what.
on record, my lord.
Insofar as the petitioner is concerned, he is to be
Please, ma'am.
released on parole,
Please.
commencing from 10.
My lords, in some prisons, my lord, they will give verification after they received an application, my lords. In some prisons, they won't give, and there should be a time limits, my lords. According to the prison manual, that should within 15 days they should give the report. But in several prisons, they will till 2 months or 3 months they will not give the report. That should be.
And that is why we'll try and e-enable the portal so that everything could be traceable and it could be time stamped to find out when what has happened.
Obliged.
Otherwise, 3 ತಿಂಗಳಾದ್ಮೇಲೆ ಬಂದು it is.
No, no, my lord. They are
They
following
are
it
entitled
within
for
time.
parole if they are.
Please.
Obliged, my lord.
Obliged.
Order, serial number 2, yes, Srinivas.
Yes, madam.
I ordered.
Only Sinchana has been shown. MR illa. Not allowed to appear. Yes, ಏನಾಯ್ತು?
My oral instruction is there is a contravention in the conditions of the acquisition. The land is in the dispute. So as per BBMP, this, my lords, the land belongs to government itself. So we have been identified the land for the.
Land doesn't belong to you.
Lord, acquisition is done, it is given, position is there with us.
And in 2 years back also, the cracker stall has been installed over there. It has, based
Lord,
on
there are
that
two
only it has
grounds.
been done.
There are two grounds, my lord. My instructions is this, there are two grounds. There is another adjacent ground which crackers were put, not in this ground, my lord. This is a sports complex exclusively used for the purpose of HMT, my lord, nobody else. And now, my lord, because it's a sick industry which is being placed, my lord, now we are only giving it to schools and colleges to play, my lord, to put up the sports activities. Otherwise, nobody else, my lord.
So what is there on these 3 days?
Lord,
Who
we
have
have
you given
already,
it?
Sheshadripuram College has been placed, my lord.
Page?
Lord, page 27, my lord. 27th of Sheshadripuram is what we've informed, my lord. And then there's also an ABB Limited and one company. Also placed that, my lord.
17th October, one day only. No
17th,
problem.
next
Fine.
day ಇದೆ. ತಿರ್ಗಾ 18th, 19th ಗೂ ಇದೆ. I've placed that also on the card.
So 18th and 19th ಇದೆ. 20th?
20th is not there.
Not.
16th to 19th to 25th to 27th we have booked.
So 20th to 25th should not be a problem.
But there, my lord, they've said it for 6 days. 6 days ಅಂತ ಕರ್ದಿರೋದವ್ರು.
ಆಯ್ತು. If they want to do it, they already let it out and
But it is
some
an
events are
exclusive.
being
And
organized.
this land was identified in way back in the month.
1965 acquisition.
18th of October. my
You
lord.
want to get into acquisition, we have to give them time to file objections.
No, I am not getting into
Instruction
acquisition.
says there is a dispute in the land. Even earlier 2 years.
So when
also
did
it
you
has been-
identify and inform them?
No, we have informed to the government, my lords. We will not inform.
When did you
because they
inform
have
them?
asked.
Till today it is not informed. Nam permission ತಗೊಂಡ್ರಿ.
How did you come?
ಅಲ್ಲ, they have come, the shopkeepers have come and told us, that is how we got to know. Otherwise, we would have not got to know.
Has not been placed, so we don't know who will come and how the shopkeepers can approach them.
They will
You
come and see
informed
the
them
place.
earlier and they have come
No,
late.
we have informed to the government, my lords. We cannot inform to this. because-
Government ಯಾವಾಗ inform ಮಾಡಿದ್ನಿ?
Unless it could be Passover for a while, so the complete instructions could be made. at-
Top of the list ಹಾಕಿದ್ದು pass over ಮಾಡಕ್ಕಲ್ಲ.
Because all are, I should not make this submission, all engineers, everybody in the census, my lord, over the phone, we couldn't make instructions. So it could be
Pass over ಅಂದ್ರೆ 2:30 ಗೆ ಹೋಗುತ್ತೆ.
2:30 ಹೋಗುತ್ತೆ, ಅಷ್ಟೊಳಗೆ submission ಮಾಡ್ತೀವಿ government ಹತ್ರನೂ ಮಾತಾಡ್ತೀನಿ.
ಹಾಗೇನು ಇನ್ನೊಂದು ಕ್ವಶನ್ ಕೇಳಿದ್ರೆ ಮತ್ತೆ pass over ಅಂತ.
ಇಲ್ಲ ಹಾಗಲ್ಲ, the time was very limited, where we couldn't commit it.
Identify.
No, the
Don't use this because if ನಾಳೆ ಮತ್ತೆ 25th is there is a cricket tournament. If the people dig all these things, it can't be used.
in case they can, that's the reason I made the submission, my lord. So
Before identifying, you should put them on notice and say that you're going to use this, and if they have objection, you should consider it.
on 26/9/2025, we have sent to the government, my lords. Later, on 26/9/2025 itself, we have sent to the government for the after identification of the land.
Before identification, it's your duty to hear them, not the government duty. Identifying is you.
No, since it was a government land, as per the BBMP records, it's been identified. It could be Passover for a minute, my lords.
Pass over, but we are going to stay this.
Lord, may I request, my lord? And ಇವತ್ತೇ draw lots, let them not do it
We are
until
going to
then.
stay it and ಆದ್ಮೇಲೆ ಏನು
until then
draw
ಅಷ್ಟೇ.
lots ಮಾಡ್ಕೊಳ್ಳಿ ಏನಾದ್ರು ಮಾಡಿ.
Stay ಮಾಡ್ಬಿಟ್ರೆ ಏನ್?
That's between both of you. Go to AC,
State, my lord, it will be
go to the
difficult.
committee, ACS committee, ಹೋಗ್ಬಿಟ್ಟು ಮಾಡಿ.
Because we have, for 4 shops, we have been.
So by afternoon, if you don't come up with another alternate space, whoever identified this space will be responsible for refunding all the money.
I'll advise.
Lord, I request, my lord, I may retire from this case because GB has made a party. I have also filed wakalats on behalf of
Your
BBA.
choice.
We
did not ask you to file.
No, my lord, GBA was not made a party, so my not next round, my lord.
ಯಾರು ಇಲ್ಲ.
I will make somebody much obliged. Yes, much obliged.
Fresh matters, serial number 3. Krishna BS.
I withdraw appear for the petitioner. my lord. The fact is, information was sought for to the commissioner, and the commissioner gives the information stating that the very record which was called for has been taken by the official privately to their residence, and the official has not replaced the records, is what the Tehsildar respondent number 1
But your
informs.
interim relief is as good as your final relief, so we'll give them time. And AGA accepts notice for respondent 1 to 3. She seeks for and is granted 10 days time to obtain instruction and make a submission.
My lords, office objections may be over. There is one, they say that,
Office objection are all now with the registrar. You move the registrar, get it over.
no, for being spoken to the High Court, ಒಂದೇ ಒಂದು
ಏನ್ ಇದ್ರಲ್ಲಿ ಏನ್ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ
complaint.
ಏನ್
My lord,
put
I'm
up
sorry,
ಆಗಿಲ್ಲ.
I'm sorry.
Because we won't be wasting time on office objection when so much list is there.
Serial number 4.
Effect of you for the petitioner, my lords. Lords, this is a matter wherein the government has to pay GST, my lords. It's a covered matter. Lordship recollect in NG Arun Kumar's case, the lordship had passed an order.
Yes. Who is the respondents here?
State appears.
The state, huh?
State for 1, my lords. BR Prashant appears for 2.
ಮತ್ತೆ notice ಹೋಗ್ಬೇಕಲ್ಲ. And AGA for respond number 1, BR Prashant for respond number 2. ಏನ್ ಅದೇನು?
Name of the council.
Name of the council. Council for the petition served 2 sets of the petition and the said councils released on 11th November.
Please, great.
Serial number 5. Akshata Shetty.
I'm appearing petitioner. We are intending to withdraw the petition. Kindly list next week, Lordship.
Intending to withdraw ಒಂದು date ಕೊಡಲ್ಲ.
Kindly list party
Record your statement and dismiss it withdraw.
ಅಲ್ಲ ಪಾರ್ಟಿಯಲ್ಲಿ ಕೇಳ್ಕೊಂಡು inform kindly list next week, Lordship.
By afternoon ಕೇಳ್ಕೊಂಡು ಹೇಳಿ pass over. It won't be listed for that sake.
Serial number 6.
6. Mr. Kadakatti, Dharwad.
There's also an objection that petitioner is address is at Dharwad anta ಇದೆ. ಅದೊಂದು objection ಇದೆ. But
Objection ಇದೆಯಾ? ಏನು
the
objection
scrutiny
ಇಲ್ಲ?
that could the impugned order is passed by in Dakshin Kannada district only.
Petitioner and respondent are Dharwad.
Yes.
Property is in Udupi.
Yes.
None appears. Counsel for KVT respond number 1 submit that he has not been furnished with a copy of the petition along with annexures. Released on 11th by which date? Released on 11th. Counsel for the petitioner is direct furnish a set of the petition along with annexures by end of day 24th. Objections if any by 6th November.
Obliged.
7. Aditya Shetty.
Appearing for petitioners, madam, filing memo for withdrawal. The
Surface
matter
matter,
has become infractious.
Memo for withdrawal.
Surface matter, Lordship.
But memo for withdrawal ನಾವು ಮಾಡ್ಬೋದು ಆರ್ಡರ್ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಲ್ಲ.
That is.
ಲಾಸ್ಟ್ ಇಲ್ವಲ್ಲಮ್ಮ ಇದು ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು ಅನ್ಸುತ್ತೆ. But there is no positive order. Petitioner is before this court seeking for the following memo of withdrawal has been filed dismissed as
My
withdrawn.
presence may kindly be noted, Lordship, on behalf of the
This
bank.
only
Vinay Bhatt.
accepts notice for respondent.
Serial number 8. MR Hiremath.
Petitioner, my lords, kindly press time.
At the request of counsel for the petitioner, 11th November.
Please.
9. Shamaraj.
Lords, petition, lords. Lords, fund matter.
Sorry, 9. ಯಾವ್ದ್ರಲ್ಲಿ?
9. Serial number 9, my lords.
9. ಇದು ಏನು ಮತ್ತೆ ಟಿಕ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಇದು ಯಾಕೆ ಇದು? ಒಂದ್ ನಿಮಿಷ ಯಾವ್ದಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗ ಯಾವ್ದು ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದಾಗಿರೋದು? 2 ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ, 5 ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ. Yes, Santosh, you are appearing 9?
9, my lords. Serial number 9, my lords, for the petition, my lords.
Yes, ಹೇಳಿ.
My lords, the fourth respondent had filed a dispute, my lords, raising that chit fund under the chit fund act, my lords, naming 46 lakh rupees, my lords, from the petitioner, my lords. My lords, without any opportunity, my lords,
What has been passed?
the DRC allowed the dispute, my lords. DRC has allowed the dispute.
Learned AG accepts notice for respond number 1 to 3. Issue notice to respond number 4 returnable by 19th November.
Serial number 10.
ಇದರಲ್ಲೂ ಅವಾರ್ಡ್ ಆಗಿದೆಯಾ?
ಅವಾರ್ಡ್ ಆಗಿದೆ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ, ಬೆಂಗಳೂರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಅವಾರ್ಡ್ is passed in Kadapa. Without seeking transfer of the decree, they have filed an execution petition here, Bangalore. An application under section 47 is filed to stating that this court has no jurisdiction since it is not a transferability court. That has been rejected.
But the property is in the jurisdiction of the execution court.
Bangalore.
Property is there.
No, section 39, your lordship.
It can be executed where the property is.
Unless it is a transfer, section 39. Unless it is a section, the transfer court, it cannot execute.
Transfer order agilva?
Illa agilla. So directly they have filed
section
39 of CPC.
But order 21 alli, is there a formal transfer required?
Formal transfer is required. When it is 2007 Supreme Court has told. And transfer decree. Lordship may kindly subsequently section 4 or subclass 4 has been introduced. Nothing in this section shall deem it to authorize the court which passed a decree to execute this. So alli
let us see the judgment. ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕೆ ಬೇಕಾಗುತ್ತೆ. ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡದೆ ಡಿಕ್ರಿನೇ ಇಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ ಬಂದ್ರೆ is a transfer order required?
It is required. Para 7 7 mile. But section 1 idadmale pending suit, the court approach with this suit may have jurisdiction over the attachment of property even outside the jurisdiction. In execution on order 21 rule 54, it may have also the jurisdiction to order attachment of property prohibiting a judgment debtor from transferring or charging the property in any way when it exercises its jurisdiction over the judgment debtor, though not over the property itself. It could be such a case issue precept in the section 46 of this court, and thereupon the court with precept is sent as to actually attach the property and the manner prescribed. Section 136 of the code provides for an order of attachment in respect of the property outside the jurisdiction of the court and sending the order of the attachment to the district court within whose the local limits property are sought to be attached is situated as provided for therein. But section 136 clearly excludes the execution of a decree within its purview, and executing against immovable property lying outside the jurisdiction of the executing court is possible in terms of section order 21 rule 3 of the code, which governs a case where particular site of a immovable property forms one estate in or tenure situated within the local limits of jurisdiction of 2 or more courts, and one of those courts is approaching for execution of a decree against that property. In a case where order 21 rule 19 has no application, the position shifts to it that if a decree holder wants to proceed against a property situated outside the jurisdiction of the court, which passed, he has to get the decree transferred to the appropriate court for the execution of a decree.
Moving the executing court. If a execution proceeding has been filed in a execution court, and then it is found that the property, if there are two properties, one property in that court jurisdiction,
one property which
another property in another jurisdiction.
It is award for money. Now they were sought to be attached in by filing execution year itself.
Was there a execution petition filed in the after the decree award had been passed, or this is the first execution?
The first execution filed directly in Bangalore itself.
Directly again problem illa.
Alla adalli they have to file a execution. Lordship may kindly see section 37 alli definition of the court which passed a decree ante. The expression court which passed a decree or words to their relation to execution of decree unless there is anything subject context be deemed to be where the decree is to be executed as to pass the exercise of appellate jurisdiction of the court first instance, or where the court first instance has ceased to exist to have a jurisdiction executed, the court which passed it, the suit wherein the decree has been passed was instituted at the time of making an application for execution of the court. 38 you lost my kind. A decree may be executed either by the court which passed it or by the court to which it is sent for execution. Then 39. Subclass 4 you lost nothing in this section deemed of 39 of subclass 4. Deemed to authorize this, as the authorized court which passed a decree to execute such a decree against any person property outside the local limits of jurisdiction. So unless she seek a precept or go to attachment madbekare, they have to seek a precept under section 46. Subsequently, they have to seek a.
If it had been filed in a different jurisdiction, it had been filed in the jurisdiction ಬೇಕಾಗತ್ತಾ ಅಂತ.
ಹೌದು. Against section 38 ಅಲ್ಲಿ, this is not the court which passed the decree. This executive is not the court which passed the decree under section 38. 39 ಅಲ್ಲಿ it is not a transferring court. Para 7 ending all of that, even subsequent to 2002 amendment ಆದ್ಮೇಲೆ, whatever the doubt there must have been.
You will have to decide this then. Issue notice to respondent. The further proceeding in execution petition number 33 of 22 filed on the, pending on the file of the 8th additional district session judge Bengaluru rural district. He stayed till the next date of hearing, more particular to consider the question as to whether a decree stroke award passed in one jurisdiction could be executed in another jurisdiction without the transfer of a decree. Process fee and copies to be furnished by end of day 17th October, failing which the interim order will stand automatically vacated.
Serial number 11. Dr. Sujata V.
Yes. What is this?
My lord, I am appearing for the appellant. We are seeking conveyance in this petition. This is a society formed by this very honorable High Court CJ judgment, my lord. And based on that annexure H, which is placed at 132, 136, page number, where the process of formation of this cooperative society itself was set in motion by the judgment of the Honorable CJ bench of this Honorable High Court, and subsequent to that, the respondent number, the builder who was not attending to the members of the cooperative society in maintenance, a contempt petition was filed, my lord. And in the contempt,
the order of the division bench?
It has upheld the cooperative society as functional.
Yes.
And subsequent to that, the builder closed the office of the society. And also he chased through some hooligans of the apartment, he chased the board members, got them beaten up, filed fake criminal cases against them, and started harassing the members also. Therefore, the society also filed a contempt petition against the builder. And that contempt petition order is not placed, my lord, but
where is this judgment of 190 in compliance? Your prayer is to facilitate execution of conveyance.
Yes, my lord.
In compliance with the specific judgment.
Yes, my lord.
Of the Honorable Chief Justice of Karnataka High Court in WA 190.
Yes, my lord.
Is there a direction that this conveyance has to be effected? Where is that direction?
It has declared that the board is functional.
Yes. Roster allogatte.
No. My lord, the Register of Cooperative Society has already issued a notice to the builder.
Madam, we don't have cooperative society roster. It should not be GMRES.
It can be, my lord, in I have placed some Supreme Court judgment.
You have asked for a direction to a cooperative society registrar.
No, I have not asked for a direction to
Who are respondent number 2, 3 and 4?
State of Karnataka and others have made.
Who are 2, 3 and 4, madam? Against whom direction? I don't know.
2 is deputy registrar, 3 is assistant
Deputy registrar of what?
of cooperative societies.
So say the full thing. It will go before that roster.
No, but I have sought direction to respondent number 5, who is the builder, who is maintaining at present
So
the,
you want us to dismiss the petition? Because you don't want to go before that roster?
before the,
Roster court of cooperative society.
okay, my lord.
A perusal of the petition and the prayers indicates that the matter relates to a cooperative society. Registrar Judicial is direct look into the matter and place it before the appropriate roster bench.
Serial number 12, Venkatesh R. Bhagat.
Writ of Mendable.
Yes, Mr. Bhagat.
As per the execution petition, sale deed was executed. It was kept pending on the ground that as on the day.
After the execution, by the court.
After sale deed was registered, kept pending on the ground that the executor's name is found in the RTC. What has happened, my lord? Devagowda executed an agreement to sell to me. I filed a suit for specific performance. It was decreed. I filed the execution.
Where is the plaint?
Yes,
or decree? Decree is between.
But Annexure C is my execution petition.
Kempamma and.
Kengamma and Devagowda is the original defendant.
Kengamma and Devagowda.
Yes, my lord. And he died. Devagowda died. I brought all the LRs of Devagowda on the Annexure C, page 31, my lord.
Yes.
The execution petition. What has happened, my lord? One person claiming to be Ashoka, adopted son of Devagowda, got mutated in his name. Then got it mutated to his wife's name, Saraswati. I will take your lordship to that mutation entry, my lord.
So the revenue records stand in
Saraswati's name.
Not in the name of.
Devagowda was there. Then
Not in the name
during
of
the pendency of the suit, during the pendency of the suit, some Ashoka claiming to be adopted Dattu Putra of the Devagowda got transferred in his name. Immediately got transferred in the name of Saraswati. Now they are not releasing my sale deed on the ground that Saraswati has there. Now permission ಕೇಳಬೇಕು.
ಹೆಸರಿಲ್ಲ ಅಂದ್ರೆ you have to get proper order.
4 ವರ್ಷ ಆಯ್ತು. ಆರ್ಡರ್ ತಗೊಳ್ಳಿ.
ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು?
ನಾನು ಹೋಗಿದ್ದೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ರೆ ಆರ್ಡರ್ ತಗೊಳ್ತೀವಿ ಅದನ್ನ ಸೇಲ್ ಡೀಡ್ ನಲ್ಲೇ ನೋಡ್ಬೋದು ಸರ್ ಲಾಸ್ಟ್ ಗೆ.
ಮಿಸ್ಟರ್ ಭಗತ್ ನಿಮ್ಗೆ ಹೇಳ್ಕೊಡ್ಬೇಕು
ಅಲ್ಲ 2021ರಿಂದ ನಾವು ಹೋಗ್ತಾ ಇದ್ದೀವಿ.
ಶಾರ್ಟ್ ಕಟ್ ಹೊಡಿತಾ ಇದ್ದೀರಾ ನೀವು?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
You go get that name deleted.
ಅಲ್ಲ ಅವ್ರ ಪರ್ಮಿಷನ್ ಅದು ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಇದ್ರೆ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಮಾಡ್ಬೇಕು ಅವರು. ಅದರ್ಸ್ ಇಟ್ ಅಮೌಂಟ್ಸ್ ಟು ಕಂಟೆಂಪ್ಟ್.
ಕೋರ್ಟ್ ಡಿಕ್ರಿ ಇದ್ರೆ ಅಲ್ಲಿ when there is no document the standing in some other.
ಅಲ್ಲ ದೇವೇಗೌಡ ಇದೆ ಅದರಂತ ದತ್ತುಪುತ್ರ ಅಂತ ಇದೆ.
ಒಂದ್ ಸೂಟ್ ಹಾಕ್ಬಿಟ್ಟು ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡ್ಬಿಟ್ಟು ಡೀಟೇಲ್ಸ್ ತಗೊಂಡು ಒಂದ್ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಬಿಟ್ಟು ಪ್ರದೀಪ್ ಕೊಟ್ಬಿಡಿ, ರೆಕಾರ್ಡ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಸೇಲ್ ಡೀಡು ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಅಲ್ಲ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಅದು ಪರ್ಮಿಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ 4 ವರ್ಷ ತಗೊಂಡು ಅದೊಂದು ಸ್ವಲ್ಪ ತೋರಿಸ್ಬಿಡ್ತೇನೆ ತಮ್ಗೆ. ಅಲ್ಲ ಒಂದು ಪೇಜ್ 39 ಸ್ವಲ್ಪ.
We have dealt with in detail. You are also in that matter, I think. The duties of the sub registrar. If the records are found in somebody else's name, merely because it is presented, it need not be registered.
But if it is a court decree, our ಮಾಡಲೇಬೇಕು.
Court decree, if there
is during the pendency of the suit, they have changed it. As on the date of suit, it is in the name of Devagowda.
ಒಂದು ಕೆಲಸ ಮಾಡೋಣ, ನೀವು ನಮ್ಮ ಮೇಲೆ ಒಂದು ಸೂಟ್ ಹಾಕ್ಬಿಟ್ಟು ವಿಧಾನಸೌಧ ತಗೊಂಡ್ಬಿಡೋಣ, ಖಾಲಿ ಬಿದ್ದಿದೆ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ನೋಡಿ ತಗೊಂಡು ಕೊಡ್ತೀವಿ. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ Annexure A endorsement
name, you get the appropriate orders.
ಅಲ್ಲ Annexure A endorsement ನೋಡ್ಬೋದು.
ಇವಾಗ ಲಿಬರ್ಟಿ ಬೇಕಾ ಬೇಡವಾ?
ಅಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ ಮಾಡ್ತಾರೆ, ಬೇಗ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾ ಇರೋದು ನಾನು ಅಷ್ಟೇ. ಅವ್ರು ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. 4 ವರ್ಷ ಆಯ್ತು ಮಾಡಿಲ್ಲ.
They cannot do that.
ಅಲ್ಲ
ಆಯ್ತು, ರಿಜೆಕ್ಷನ್ ಒಂದು ಆರ್ಡರ್ ಕೊಡಿ ಅಷ್ಟೇ ಬೇಕಂತ ಕೊಡಿ. Petitioner is learned AG accepts notice for respondent number 1 and 2. Petitioner is before this court seeking for the following briefs. Petitioner had filed a suit in OS number 80 of 2006 for specific performance which came to be decreed. Pursuant to the same, in execution proceeding number 195 of 2008, a sale deed came to be executed in the name of the petitioner. The said sale deed having been presented for registration has been kept pending, and is in that background that the petitioner is before this court seeking for the aforesaid relief. Submission of Shri Venkatesh Bhagat, learned counsel for the petitioner, is that during the pendency of the suit, one third party claiming to be the adopted son of the defendant had got his name entered in the revenue records, And it is for that reason.
And thereafter, his wife's name, Saraswati.
And thereafter, on his expiry, na?
Howdo.
Thereafter, on his expiry, by way of inheritance, the name of his wife came to be entered in the revenue records. And it's for that reason that the respondents have not registered the sale deed, or registered and released the sale deed. His submission is that the Inspector General of Registration and Stamps has the power and authority to direct such registration and release.
Annexure A endorsement is given regarding that matter.
In that view of the matter, the Inspector General of Registration Stamps is directed to consider the application filed by the petitioner and pass necessary orders within 2 weeks from the date of receipt of a copy of this order.
13.
Petitioner. My lord, the petitioner has sought for, my lord, some information, my lord, in which case, my lord, the petitioner and one private party had some criminal proceedings, my lord, 138 proceedings.
There is no interim relief.
No interim relief, my lord. Only information sought was rejected.
Information sought for as regards?
My lord, as regards, my lord, the details of, my lord, LOC issued against a private party, my lord, and his detention and release details were
Why
sought.
do you want that details?
My lord, there is a 138 proceedings between the petitioner and the private party, my lord.
That particular private party?
Yes, my lord. And during the, my lord, proceedings, he did not appear, NBWs were issued, then ultimately LOC was issued, my lord, and when he was, my lord, apprehended, my lord, in the Bombay airport. I wanted the details of that proceedings.
Why do you want those details?
My lord, there are proceedings, my lord, documents which says, my lord, he was, my lord, executed.
Make an application before the court. If the court feels it's required, it will secure it.
Information was rejected, my lord, on the ground that, my lord, it, my lord, comes within section 8(1)(h) of the act, my lord.
Private right, private party.
My lord, the 8(1)(h), my lord, deals with this specification where, my lord, the information sought, my lord, comes in the way of, my lord, investigation. Then, my lord, that could be rejected. My lord, here investigation, there is no investigation. But there is a private dispute between the two parties.
Yes, but their investigation, their investigating documents you are seeking for.
My lord, I am not seeking investigation
LOC ಅಂದ್ರೆ ಏನು? ಅಲ್ಲಿ ಏನೇನಾಯ್ತು ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ನೀವು ಕೇಳಿದ್ರೆ
page 19 ಅಲ್ಲಿ page 19 ಅಲ್ಲಿ ಅವರ passport details page 19 details of information sought, my lord. Description of the information required, my lord, lordships get, my lord. Copy of the passports of the accused Karan so and so. Date on copy of LOC against him. Any information, my lord, available.
All information, any alla.
That is, my lord, I stated, my lord, all information record available with. My lord, if they are not having, they could have given. My lord, this.
They cannot give you this information. This is required for their investigation.
My lord, there is no investigation pending, my lord. My lord, 138 proceedings alli.
ನಿಮ್ಮ 138 proceedings ಅಲ್ಲಲ್ಲಪ್ಪ LOC ಏನಂತ ಕೊಟ್ಟಿದ್ದು
ಕೋರ್ಟ್ ನವರು ಇಶ್ಯೂ ಮಾಡಿದ್ರು
ಯಾವುದರಲ್ಲಿ
138 proceedings ಅಲ್ಲಿ
not in another proceeding.
No, my lord, no.
Your lordships may kindly
you make an application to the court to summon these documents.
There will not be any such, my lord. Now kindly
the court deems it fit, it will summon the documents.
My lord, I want it in other proceedings to be produced for this reason.
They can, don't misuse these proceedings of RTI. If you want, these are all criminal matters. Right to privacy is also there.
No, it does not, my lord, come in the way of any of the personal information of the accused, my lord, so as to attract, my lord, even 8(1)(j).
You make an application in the court that you want these documents. If the court feels it is required, it will summon.
I wanted to produce in other court proceedings, my lord.
So you get it here and produce it there. If
my lord, the difficulty would be, my lord, I cannot get any information, my lord, if they under
then
the
don't
RTA.
get it.
The difficulty is, my lord, he swears affidavit at, my lord, when he was in abroad and places before the honorable court and, my lord, gets an interim orders and all. My lord, these document I want to, my lord, place before the court, my lord, to show that, my lord, he has played fraud upon the courts. But therefore I have sought for information. The information sought is, my lord.
So LOC was issued in this matter. You ask for it to be produced there.
My lord, it is the details of the information, my lord, not in the court, my lord, but with the authority. My lord,
file an application. We have told you 5 times. Now
I
you want to
understand.
say again.
If lordship you observe that, my lord,
file an application.
It's
And
also
AGA
observed, my
accepts
lord, that SLP, there is a specific, in page 14, my lord,
notice.
R1 has specifically, there is an order that, my lord,
Page 14.
81J ಅಡಿಯಲ್ಲಿ ವೈಯಕ್ತಿಕ ಮಾಹಿತಿಯಾಗಿದ್ದು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋನ್ಸು ರಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶ ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಅಯೋಗ್ಯ
Swami's
ಸದರಿ
judgment.
Personal information.
Justice Swami's judgment is clear on this para 121 and nodi.
ಹೌದು.
These are all private public right to privacy al cover ಆಗುತ್ತೆ.
ಸರ್ ಅವ್ರ LOC ಅಲ್ಲಿ ಇಶ್ಯೂ ಆಗಿ ಅರೆಸ್ಟ್ ಆದ್ದು ಪ್ರೈವೇಸಿ
Right to be forgotten ಇದೆ ಇವಾಗ. ನೀವು ಒಂದ್ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳ್ತೀರಾ. ಎಲ್ಲ ಲಿಟಿಗೇಷನ್ ಆದ್ಮೇಲೆ ರೈಟ್ ಟು ಬಿ ಫರ್ಗಾಟನ್ ಡಿಲೀಟ್ ಎವ್ರಿಥಿಂಗ್ ಅಂತಿದೆ. Things have changed.
The authorities also changes, my lord. One authority says 81H is a bar. The other authority says
ಎರಡು ಹೇಳಿದಾರಪ್ಪ.
81J is bar ಅಂತ ಹೇಳ್ತಾರೆ.
And AGA accepts notice for respondent number 134. Shri Sharat Gowda accepts notice for respondent number 2. Petitioner is before this court seeking for the following reliefs. The petitioner had filed a complaint in a private complaint. Straight CC ಹೋಗ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Please, my lord.
Had filed a complaint under section 138 of the Negotiable Instruments Act, which subsequently came to be registered as CC number 467 of 2022 on the file of the JMSC Puttur, Dakshina Kannada. In the said matter, the accused, having absconded, a lookout circular had been issued, in pursuance of which the accused had been detained at Mumbai International Airport and later released. The petitioner had made an application under the RTI Act for furnishing of copy of the passport of the accused, the date on which the LOC was issued against the accused, copy of the LOC issued against him, all information stock records available with SP Mangalore office about the detention of the accused at Mumbai International Airport on 1/12/23 and about his release on 1/12/23. The said application came to be rejected by respondent number 4 on the ground that
81H,
81
page 14, my lord.
81J.
Annexure C.
on the ground that the information sought for cannot be granted in terms of the decision of the Honorable Apex Court in SLP number 27734 of 2012, as also under section 81H, 81G.
My lord, initial rejection annexure C, my lord. It's appeal order, my lord. Annexure is appealable. Order passed in the
ಇದು
appeal.
appellate.
ಹೌದು. Annexure C, sir.
Annexure C was rejected by respondent number 4 on the ground.
81H, my lord.
Annexure
C, page 14.
on the ground that the same cannot be granted under Rule 81H of the RTI Act, and further on the ground that the document sought for pertains to special branch, and in terms of notification issued, the RTI Act does not apply to special branches in district police offices. Challenging the same, the petitioner had approached the third respondent, who rejected the said application on the ground
Appeal, my lord.
that
Non-speaking order, my lord. Annexure B, page 13.
the rejection was proper and correct. An appeal having been filed before the second respondent, the second respondent rejected the second appeal on the ground that in terms of the decision of the Honorable Apex Court in SLP number 27734 of 2012, the information sought for relates to is a personal information, and as such under section 81G cannot be granted. It is challenging these orders. The petitioner is before this court. A perusal of the above, from the perusal of the above, it is clear that the petitioner has sought for a copy of the passport, copy of the LOC, and all documents which are available with the SP Mangalore in relation to the same. The documents relating to 81H, right information. Section 81H is reproduced here under for easy reference. The exemption under section 8 is available to information which would impede the process of investigation or apprehension or prosecution of offenders. Apart from 81H, respondent number 4 has categorically rejected the same on account of the RTA Act not being applicable to special units in terms of the notification issued under section 24(4). Section 24(4) is reproduced hereunder for easy reference. A perusal of subsection 4 of section 24 would indicate that nothing contained in the RTA Act would apply to such intelligence and security organization being organized and established by state government, as that government may from time to time by notification the official gazette specify. Since it's contended that a notification which has been issued exempting the special branches of the district police officers in terms of subsection 4 of section 24, the RTA Act would not be applicable. Be that as it may, even the second respondent information commission, taking into account the judgment of the Honorable Apex Court in Justice Putswamy's case, has come to a conclusion that the information which has been sought for to be governed by the law of privacy and as such cannot be granted. And reference has been made to section 81G. Section 81G is reproduced hereunder for easy reference. The disclosure of the information, like a passport, in my considered opinion, would cause immense harm and injury to a person. The details of a passport are private to a person, and if those details of a passport are made available to any third party, including the petitioner who has filed the 138 proceedings, it could cause a danger to the life or physical safety of the concerned person. In that view of the matter, I do not find any infirmity in the orders passed by respondent number 4, subsequently by respondent number 3, and then by respondent number 2. In the event the petitioner seeks for or is required, and the said information is required for the prosecution of the proceedings under section 138, the petitioner could always make an application in the said proceedings for summoning of those documents, which the court, in its wisdom, could consider With the above liberty, the petition stands dismissed.
Great.
Number 14.
Serial number 14, I appear for the third respondent in this matter.
Yes, Mr. Reddy.
I am for the petitioner, my lord. This is, my lord, the petition against the order of the Deputy Commissioner before this honorable court under the Senior Citizenships Act, my lord. I would like to notice, my lord, Annexure A.
Any settlement possible?
Lord, it is a case where my father, my lord, executes a registered gift deed in my favor. My lord, I take loan, I put up construction. My two sisters, my lord, set up my father to file such a petition. That was allowed, my lord. This honorable court remanded the matter back to the, my lord, the proceedings back, stating, my lord, that the contents of the gift deed is to be seen. There is no condition that is attached.
Question Mr. Reddy. Any settlement possible, any mediation? Yes or no?
I can advise my client, my lord, to oppose the mediation.
Fact, my lord, the availing, I produced all documents relating to that.
ನೀವು ಎಸ್ ಅಂತ ಹೇಳಿಲ್ಲ ನೋ ಅಂದ್ರೇನು ಆಯ್ತು.
Agreed, my lord, that as per my knowledge is concerned, it is not possible. However,
then argue them.
However,
ಬೇಡ, not possible ಅಂದ್ರೆ ಬೇಡ. Argument.
Because I discussed already on that aspect. That is the reason.
If it is possible, because it is Father and son.
The fact, my lord, the on the retirement amount, immediately I purchased the scheduled property with an intention to put up the construction. At that point of time, I was required certain financial assistance, so that I discussed with this particular respondent, and he after certain this one, my lord, the queries, he told you transfer the property because you are retired person, no loan will be given, so that I will make this one. Then, my lord, after executing this particular gift deed, my lord, he owed the loan formal this one, and the same within 3 months he has repaid that particular amount.
Who has repaid?
My son repaid that amount. I produced the mortgage deed also before this honorable court, the discharging mortgage deed. So he has not spent any amount for the construction. Without any other option, I availed the financial assistance from my daughter, and even this particular son is not, and his wife is not able to look after my wife. She was cancer patient. I am also suffering. None of these particular son and daughter-in-law are ready to look after, and they expelled me after construction of the house. And thereafter, I filed the petition before the Assistant Commissioner. He was allowed, and the gift deed was executed. There is no particular investment of any rupees by the son, my lord. Then, my lord, he filed the writ petition before this honorable court, and the honorable court directed the Deputy Commissioner to pass the order. But that order is also produced, my lord, the ink page number 70, my lord, annexure J, that is literally the against to the provisions of section 60. That section 16, my lord, he cannot, the Deputy Commissioner has no jurisdiction to try this particular appeal filed by the son.
Yes.
The provision, it says, any senior citizen.
Nimde appeal. Nimde appeal. Neeve hogide. No jurisdiction. Neeve ಹೇಳ್ತೀರಾ. ಆಯ್ತು.
So, not mine appeal. It is not mine appeal.
Your appeal.
No,
no, it's the son's appeal.
My lord. So, that particular things.
So you succeeded before the Assistant Commissioner.
Yes, my lord. So that particular order of the Deputy Commissioner is void in ab initio against section 6.
ಅದಕ್ಕೆ ನೀವು settlement ಪಡ ಅಂತ ಇದೆ.
Lord, I would like to submit this. Not when writ order came to be passed, Lord, they did not object that the Deputy Commissioner did not have jurisdiction. Lord, once I come to know, Lord, that the writ order was not correct, Lord, I filed a review petition before this court saying that Deputy Commissioner cannot pass such an order. Then this honorable court has taken a view. No, I have remanded the matter. It is for the Deputy Commissioner to take a decision on merits. Not when I have made all possible efforts before this court to see that the matter, my lord, is taken up on merits.
Now you'll have to come on a writ petition, Mr. Reddy. Division bench is very clear.
My lord, but the review order, my lord, your lordship may kindly see, they have not chosen to disclose the review order.
So review order has let the DC take his decision.
Howdo?
DC could have said I don't have jurisdiction, dismissed it.
Illa. The Deputy Commissioner has allowed the appeal.
Adike,
Deputy Commissioner has allowed the appeal.
He could have said I don't have jurisdiction, dismissed it.
But the court
then
order
appeal by a person other than a senior citizen is not maintainable.
That is true, Lord, that I made efforts before this honorable court to see that the writ petition is revived. Instead of not going back to the Deputy Commissioner, the writ petition itself can be taken up for consideration on merits.
Yes, but now, when there is no jurisdiction of the Deputy Commissioner, that order is a nullity. What will you do with that order?
Lord, now I am faced with a situation where the order of the Assistant Commissioner is already set aside. Unless it is not the order of the Deputy Commissioner is set aside in a manner known to law.
You have to just say it's a nullity, then it is gone.
Not even if a nullity order needs to be challenged, not according to me. Otherwise,
writ petition will say that it's a nullity. There is no jurisdiction.
Not what I can do, Lord, is I can file another writ petition, Lord, challenging the Assistant Commissioner. And Lord, both these writ petitions can be taken up together.
No, because this is a nullity, it goes.
Lord, Your Worship may kindly see, Lord. Lord, if this particular order is set aside, now what happens is not my father, during the pendency of the proceedings before the Deputy Commissioner, has executed a registered gift deed in favor of my sisters. That registered gift deed is also produced before the court. Now, my lord, once he has executed a registered gift deed, not whether he can challenge once again, my lord, before this honorable court by way of filing a writ petition. He does not have locus standi. Lord, you may kindly see the gift deed that has been produced before this honorable
He
court.
has succeeded before the Assistant Commissioner.
That's true, my
You
lord.
did not succeed. If you had succeeded, you could have had this ground. You failed before the Assistant Commissioner, you went before the Deputy Commissioner. The order of the pending proceeding before the Deputy Commissioner. That's not a right, and there's no right with you. You have to challenge it. We can't advise you what to do, but you'll have to challenge it in appropriate forum. And AG accepts notice for respond number 1 and 2. Shri C. Shankar Reddy, who has filed caveat for respond number 3, accepts notice for respond number 3. Petitioner is before this court seeking for the following reliefs. Respond number 3 had filed a proceedings under section 23 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007 before the second respondent Assistant Commissioner, which came to be allowed. Challenging the same, the petitioner had filed an appeal before the Deputy Commissioner. You had challenged it in a writ petition or?
I filed a writ petition before this court.
Petition
Before this court. I did not approach the Deputy Commissioner. This
Challenge
court,
the same.
writ proceedings, said you approach the
By
Deputy
way of a writ petition. In WP number 14107 of 2022 and while order dated 25th June 2024, what we can only do is we can direct the registry to place this matter before the same judge so that you could make your submissions.
Please, man, please, that could be done, my lord. Otherwise, my lord, writ order is there, review order is there.
That is, my lord, the order itself is nullity, then.
Judge is still serving, so you can go before him and ask what is to be done.
No, if, the thing is, the order is already passed. On basis of the writ petition, contrary to the section 16, my lord.
Yes, but
so it is the forum for him to file the separate writ petition. That is always there.
No,
but he had rightly come before this court as a writ petition.
True,
but after the order, there is no other forum. It's only the available remedy for the petitioner, my lord.
In the writ petition, the order of the Assistant Commissioner has been set aside.
Because of an order of the court, he cannot be at a disadvantage. He had rightly come before this. If he had gone before the DC and then had come on appeal, we agree with you. He had rightly come before this court. But that was dismissed on account of alternative cases remedy, which is not there. Review petition no hakadru. If you had gone before the DC and come here, you are absolutely right. But not when he has come directly. It should not be.
That is there, my lord. However, the provision of law, my lord, I am certain.
Since the petitioner was required to approach the Deputy Commissioner in view of the order dated 25th June 24 in WP number 14107 of 2022, the petitioner, the petitioner, respond number 3. The respond number 3 submit that it is that respond number 3 has only complied with the orders passed by this court, and as such, the present writ petition could not be considered on the ground that respond number 1 did not have jurisdiction to consider the appeal. In that view of the matter, registry is direct in view of the said submission. Registry is direct place the above petition before the judge who had passed the order dated 25th June 2024 in WP number 14107 of 2022.
Wait, wait.
15. Page AM.
Yes.
Prior to the petitions, my lords. Writ of mandamus, my lords, directing the respondent number 2 KIDB to consider representation, my lords, for defreezing of the accounts, my lords.
Defreezing of it.
Defreezing, my lords.
KDB has frozen your account.
Yes, my lords, because of
There
pendency
was
of
a suit, my lord, by misrepresenting, my lord, the amount of compensation disbursed by executing, my lord, 29(2), my lord, the agreement. Therefore, my lord, after coming to know that, my lord, there is a suit, my lord, there is a last injection order.
What you have given to them, you are freezing.
The compromise petition, the parties have entered into compromise, my lords, and the OS also has been disposed of, my lords. May kindly peruse page number 66 of my petition. I have annexed the case status wherein the matter before the Devnali court has been disposed of in terms of the settlement between the parties, my lords. I have also issued representations to the bank, my lords. When I have approached them,
ಕರೆದ್ಬಿಟ್ಟು ಎಲ್ಲರ ಹತ್ರ affidavit ತಗೊಂಡು ಮಾಡಿ.
ಮತ್ತೆ ಅದೇ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. I'll just seek instruction whether, my lord, the dispute between the, my lord, these persons in the OS are not, my lord, any other.
Let them come and give you affidavits. That the amount can be, the release is proper.
Please.
We'll record that, let them do it and you then take care of it. Pradeep accepts notice for respond number?
Respond number
1 and AGA for respond number 2. Union Bank of
1
India?
and 2, my lord, I accept notice.
We are not going to be serving SLO on you at all. SLO will only be the state.
Please.
Union Bank of India?
Vignesh Shetty.
Vignesh Shetty, Karnataka Gramin Bank?
TP Muttanna.
TP Muttanna.
TP Muttanna. Petitioner is before this court seeking for the following griefs. The grievance of the petitioner is that the respondents had directed, respondent number 1 had directed respondent number 3 and 4 to freeze the bank account of the petitioner.
petitioners, my lords.
Petitioners on account of there being a dispute between the petitioner and other family members as regards the compensation which had already been disbursed by respondent number 2 to the petitioners. Submission of learned counsel for the petitioner is that the dispute between the said petitioner and the third parties in OS number 1961 of 2020 and OS number 185 of 2020 have been resolved and there are no particular disputes which are pending between them. And as such, the order of freezing the account of the petitioners cannot be continued. The Pradeep Learned Counsel for respondent number 1 would submit that if all the parties approach respondent number 1 and submit necessary affidavits.
Respond number 2.
Respondent number 2. Respondent number 2. Learned AGA submits that if all the parties were to approach respondent number 2 and submit necessary affidavits and comply with the necessary documentation, that they have no objection as regard the release already made in favor of the petitioners, necessary orders would be passed. The said submission of learned AG answers the grievance of the petitioner, reserving liberty to petitioners and petitioners to obtain such documentation as is required of by respondent number 2 and submit the same to respondent number 2, which shall be considered necessary orders passed by respondent number 2 within 15 days of such submission. The petition stands disposed.
16. T.N. Nanja Reddy.
Ready?
There is an order of temporary injunction granted by the
ex parte na final?
ex parte.
Ex parte ಹೆಂಗೆ Mr. Reddy? ಇನ್ನ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಪ್ಲಿಕೇಶನ್?
ಪೆಂಡಿಂಗ್ ಇದೆ.
ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆಗಂಗಿಲ್ಲ ಅಂತಾನೂ ಇದೆ ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್.
ಇದು ದಿ ಮಿಲಡ್ annexure J. The direction of this honorable court in identical matters. Page Millard 42. Last annexure.
ಏನಿಲ್ಲ ಇಂಜಂಕ್ಷನ್ ರಿಸ್ಟ್ರೈನಿಂಗ್ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಏನು?
Interference.
In terms of this, your lordship can dispose.
Until service on respond number 4, we can't pass any orders.
Sir, I will take note.
And AGA accepts notice for respond number 1 to 3. Issue emergent notice to respond number 4, returnable by 12th November. Counsel for the petitioner is permitted to serve the counsel for respond number 4 before the trial court.
Bless.
17. P. Prasanna Kumar.
Lords, I appear for the petitioners in this case. Lords, I filed a GM police petition. Lords, the protection I have sought is, Lords, on a civil dispute, Lords, which is pending consideration before the Honorable Civil Court. Lords, the police are interfering with my lawful possession without any order. May I request your Lordship to kindly see the representation I've given to the Commissioner of Police.
You're not given a complaint, you're given a representation to the police. They're not used to receiving representation.
Please, if your Lordship sees page 20, Lords, may be permitted to read one para, Lords. Para. It is further submitted that when the second round of litigation in OS number so-and-so is pending adjudication, without any verdict or order of dispossession against us, the above said persons, namely so-and-so, approached the jurisdictional police station, Oscote town, in order to dispossess us unlawfully and illegally without any orders from the court. But the police would come to my property, break open the locks, and would forcefully throw us out of the property without there being any order.
Good to see you appear this side and argue this.
Lords, I'm very conscious of the fact of the submissions I made from... Therefore, the only interim protection I saw.
How is the police doing this?
I'll seek instructions. I'll seek instructions.
And AGA accepts notice for respond number 1 to 4. Notice to respond number 5 and 6 is deferred for now. Board of Waqf here
Sabah Sultana.
for respond number 7. And AGA is directed to secure instruction, make a submission as to on what basis the police officers have called upon the petitioner to surrender the premises and hand over the keys to the premises allegedly belonging to the petitioners. Released on 23rd October.
May I kindly see the interim prayer I've urged. The only thing is
until then, respondent officers are restrained from interfering with the possession of the petitioner.
18. D. Pradeep.
Yeah, for petitioner. Claim petition before MSCT is barred by limitation.
Limitation. Issue notice to respond number 1 to 5, written up by 1911. Though the proceedings in MVC number 1692 of 2024, pending on the file of the third additional judge and member MACT, Court of Small Causes, Bengaluru shall go on. The said court is restrained from passing final award in the matter. Process fee and copies to be furnished by end of day 17th October, failing which the interim order will stand automatically vacated.
Please.
19 same order. Huh?
Please, ma'am.
Issue notice to respond number 1 and 2, MVC number not called.
In serial number 50 and 55 also, ma'am.
50 and 55. Huh?
Please.
50 and 55, same order.
Please.
1911.
21. Serial number 20.
20. Passover.
21.
21.
The council on record, my lords, has a bereavement in the family. I'll appear on his behalf, my lords.
Please.
This matter, my lords, throws up an interesting question about what happens to an adjudicator's order, my lords. An adjudicator, my lords, is appointed in terms of a construction contract before the arbitration proceedings.
Arbitrator.
Adjudicator is appointed before the arbitrator. There is an in-house adjudicator that is appointed. Now, my lords, the adjudicator has passed an award in matter. And the conditions of the contract, my lords.
Where is that particular clause?
Lords, the dispute resolution clause will find at page number 414. That is the second volume, my lords.
414.
Lords, the agreement is very large.
414, volume number?
2, my lords. Third volume is there. Lords has 414, my lords. Clause 24.
Yes.
Clause 23, I'm sorry. The adjudicator shall, lords, is the appointment of adjudicator. The adjudicator shall be appointed jointly by the employer and the contractor at the time of the employer's issuance of the letter of acceptance. If in the letter of acceptance the employer does not agree on the appointment of the adjudicator, the employer will request the appointing authority designated in the PCC to appoint the adjudicator within 14 days of such receipt. Should the adjudicator resign or die, that, my lords, is not relevant. Then 24.1. If the contractor believes that a decision taken by the project manager was either outside the authority given to the project manager by the contract, or that the decision was wrongly taken, the decision shall be referred to the adjudicator within 14 days of the notification of the project manager's decision. The adjudicator shall give a decision in writing within 28 days of receipt of notification of a dispute. 24.3. The adjudicator shall be paid by the hour at the rate specified in the PCC together with reimbursable expenses.
28 days, and 28 days it becomes final.
Yes.
So when was the order of the adjudicator here?
My lords, the adjudicator's recommendations, my lords, are on 21/9/2024. That is available at page number 499 at Annexure F.
499.
That's correct. 499 is where it begins. Lord, this adjudicator is named by the employer themselves. So the CNN and the Kaveri Niravari Nigam Limited, lords, they have chosen the adjudicator. It is not that I have chosen the adjudicator. This is an adjudicator of their choice. Thereafter, my lords, they have also called upon me, my lords, to pay the adjudicator fees also by themselves. So there is no demur. What I'm trying to demonstrate before your lordships is that there is no demur regarding the choice of the adjudicator. There is a post facto letter also from them, which says that come forward and pay the fees that the adjudicator to the adjudicator.
How do you enforce the adjudicator's order?
Lords, how do I enforce is one, my lords, that is one. And secondly, my lords, what happens to it? Now, my lords, if the other side were to come and say go arbitrate, because there is an arbitration
That is 28 days over.
Yes, my lords, that is what, my lords, there is, to the best of my knowledge, my lords, there is nothing on by this honorable court on this point. But my lords, the division bench of the Kerala High Court and a single bench of the Kerala High Court, my lords, have considered this issue, and it is the same order as in the single bench's order has been taken up to the division bench, my lords, and been confirmed, my lords. First, my lords, has the single bench order, my lords. That is WP number 19299 of 2021. There, my lords, paragraph 2 is the facts. It's exactly the same. Even here, my lords, the facts are the same, that there is no action that has been taken. The reasoning, my lords, will find at paragraph 13.
There they went for arbitration.
My lords, there what happened was there was an adjudicator's award that was passed in respect of certain claims. The employer did not challenge the adjudicator's award, but certain other claims were referred to arbitration. So insofar as the claims that were awarded by the adjudicator, my lords, the contractor goes for files a writ petition to enforce that part of it. In that sense, it's the exact same factual matrix. Here, the only difference is that there is no arbitration of any sort. In that, there was an arbitration of some sort. Here, there is nothing. And I have written multiple representations, my lords, to the paragraph 13, my lords, will find the reasoning. The reference of dispute to the adjudicator was to truncate the dispute between the parties, just like a procedure prescribed under the Code of Civil Procedure for admission and denial, where on the basis of the document some claims were admitted. KACBL never challenged such findings of the adjudicator in favor of the petitioner.
Our question was different.
Yes, my lords.
Okay, now, even if we say adjudicator's order is final, how do you enforce it?
No, there is no enforcement mechanism because the arbitration, in terms of the Arbitration and Conciliation Act, this is not an arbitration, this is not a conciliation, this is not a mediation. Because the conciliation and mediation have a sense of consensus ad idem, which is not there. It is a sort of adjudicatory mechanism, but it's not treated to be an award per se. So, my lords, I have written a representation because they're a state authority. I've said this is the adjudicator's award. I've given a representation and come before this court for mandates.
Assuming that we accept everything that you say.
Yes, my lords.
And say it's an award or adjudicator has passed a But that award won't be arbitration. How do you enforce it?
Then I'll have,
What will you get out of this petition?
my lords, then what is the point of this mechanism itself?
Exactly.
Because I'll draw a
That
parallel.
you should have thought of when you signed the agreement.
My lords, this is standard form contract. This is then
Saying
every
how do you
contract.
enforce it?
My lords, if I may draw a parallel, in CMPs, my lords, if my lords was sitting and I come to the CMP without exhausting this adjudicator phase, I will be non-suited by your lordships. I would be non-suited by your lordships only on the ground that I have not complied
The
with them.
counsel for CNNL.
Lords, Mr. KS Bhimaya has filed petitions in the year 2025, lords. I checked online.
Kaveri. Kaveri.
BR Prashant, B.
Prashant BR is directed to accept notice for respondent 1 and 2. Counsel for the petitioner is directed to serve 2 sets of the petition along with annexures on the said counsels. Released on 3rd November.
Same stage. Same stage.
Preliminary hearing.
Obliged.
22. Yes, Satish Kumar.
Director for the petition. Yes, I have sought for writ of mandamus, my lords. Petitioner, with regard to issuance of the transfer certificate, my lords. Petition number 1 and 2 I have adopted petition number 3, my lords, when in the year 2018, my lords. Now, in the year 2018, the petition number 3 was in second standard. Up to that, there was a entry of the natural parent's name. And subsequent to my,
You adopted.
please, I have adopted.
And
Birth
AGA
certificate,
accepts notice for respondent number 1 to 3. Respondent number 4.
4 is a private respondent. It's a school, my lords.
Government school or
Illness one,
private school?
Private school.
Issue emergent notice to respondent number 4 returnable by 13 November. Counsel for the petitioner is also permitted to take out and summons in respect of respondent number 4. To include their name as the parents.
The birth certificate has already.
Minor child. Oh, Dhimai MG to Dhimai SR ಮಾಡಬೇಕು ಅಂತನಾ?
Please, ma'am.
And
Based
name
on the
of-
birth certificate, based on the birth certificate has already been issued in the name of whatever prayer I am seeking, minutes. That has
Where is
not,
the birth certificate?
page number 29 minutes, 24 minutes, annexure B. Yesiru, Dhimati Yesam. Pursuant to the adoption deed, my name has been changed already. I'm only requesting to add this name in the transfer certificate. Now I have changed the school, they are not issuing the transfer certificate. The competitors are already recognized and considered my card.
Same.
Obliged.
23. Yes, Venkata Subbarav.
Petition.
Yes.
Understand. The revision or annex A and B. Revision 2023. Page number 1187.
No interim relief. And AGA accepts notice for respondent number 1 to 3. 4 go. Executive officer Nivena. Respondent number 4. Counsel for the petition furnished 2 sets of the petition along with annexes on land AGA, who seeks for 2 weeks' time to obtain instruction, make a submission, released on 11th November.
Much obliged.
24. D. Malaswamy.
Yes, Mr. Alaswamy.
My lord, there's an interim order which was passed, my lord, in a suit for injunction, my lord, after hearing both the sides, my lord. Subsequently, my lord, an application for police protection was also, my lord, allowed, my lord, after hearing both the sides, my lord.
Injunction restraining?
Restraining the defendants, my lord, from interfering with my possession, my lord. Not only my lord, my father had filed a suit earlier, my lord, that was also decreed, my lord. Now, my lord. Now, kindly see, my lord.
Where is that order of police protection?
Police protection, my lord, at page 50.
75.
66, my lord.
7. Question 75. Yes, madam.
I'll take instructions, my lord.
In instructions. Not in this matter. When there's already an order, there's no.
Yes, my lord, they have to give, I'll ascertain whether they've already given or not. Otherwise, my lord may
AGA
give
accepts
a
notice
direction.
for respondent 1 to 3. Issue notice to respond number 4 to 8 is deferred for now. Learned AGA He is directed to secure instruction, make a submission as to why, despite the order dated 1/9/2025, the jurisdiction police have not granted police protection for the implementation of the said order. An affidavit of respondent number 3 to be filed in this regard.
Lord, the direction may be given to give police protection.
Hmm?
They have not given police protection.
Not
They have
given.
received their instruction.
If police protection has not been given by now, since apparently police protection has not been given and the order has not been complied, respondent number 3 is directed to comply with the said order and submit a report.
Yes, ma'am.
Released on 30th October.
25, Abhishek MB.
Lordship, I challenge the notification issued by the R3, Your Lordship. The petitioner herein, the society, having been allotted a fair price shop, Your Lordship, under the license issued at Annexure B, Your Lordship. The license, which is renewed up to the date of 2026 by the R3, who issued this simping notification, Your Lordship. When the license being subsistence, Your Lordship, the impugn notification just came to be issued and calling for application from all the interested person to establish a new fair price shop in the same locality, Your Lordship.
How many ration cards are attached to you?
902, Lordship.
How many are they required minimum?
562, which is assigned for new allotment under the notification. 562, Your Lordship.
Minimum number idella.
Even in the clause 11 of the Karnataka Essential Commodities Public Distribution System Control Act, it would be in violation of clause 11, Your Lordship. I would only remind 340 ration cards. If this notification is acted.
Rural area alla nimdu 500 ide nimdu.
902, Lordship.
902 ide.
Yes, sir.
So 500 ನಿಮಗೆ ಕೊಡ್ತಾರೆ, 402 ಇನ್ನೊಬ್ಬರು ಕೊಡ್ತಾರೆ.
The notification itself is arbitrarily issued, my lord, because there is no survey which is mandated on this.
Here that your 902 cards are attached to you. What more is required?
It could be violation of clause.
Violation of what? Violation of your business interest.
If the
you are only entitled for protection of your minimum number of 500.
Yes,
That's all.
Yes, Lord.
That is what will direct them. Anything above them, they can issue a notification. You cannot say everything will belong to me only.
My lord, the notification.
ಎಲ್ಲ ಕೇಸ್ ನನಗೆ ಬರಬೇಕು ಅಂತ ಹೇಳ್ಬೇಕು. ಹಾಗೆಲ್ಲ. And AG accepts notice for respondent number 1 to 5. Petitioner is before this court seeking for the following leaves. The petitioner is a society registered under the Karnataka Cooperative Societies Act 1959 and had been granted an authorization to run a fair price shop in Ullu Madenalli village. The said authorization has been extended from time to time and is in currency until 8/11/2026. The petitioner is before this court challenging the notification dated 1/9/2025, which has been issued inviting applications for one other fair price shop in the said area. Submission of Shri Abhishek MB, Learned Counsel for the petitioner, is that the license of the authorization of the petitioner has been extended until 8/11/2026. No fresh authorization could be issued in the very same area. And as such, the notification which has been issued is completely arbitrary and violative of the rights of the petitioner under Article 19(1)(g) of the Constitution. And as such, is required to be quashed. I am unable to agree with the submission of the Learned Counsel for the petitioner, inasmuch as The authorization in favor of the petitioner has not been disturbed. There is no cancellation of the said authorization, which has been resorted to by respondents. The respondents have issued one more notification for establishment of one more fair price shop, taking into consideration that there are more than 900 card holders in the said area. In terms of regulation 11 is reproduced here under regulation 11 of so and so order is reproduced here under for easy reference. 92 or 17. Of 2016 is reproduced here under for easy reference. A parallel of the above would indicate that the number of ration cards assigned to a fair price depot shall not be less than 500 for a fair price depot in a rural area. In the present case, the fair price depot is in a rural area, and as such, what is required to be seen is the guarantee which has been provided thereunder is that the number of ration cards will not be reduced less than 500, so as to make the activity of the authorization holder viable and economical. The same does not provide for a situation where no other fair price depot can be established in that locality. The interest of the petitioner and or the right vested with the petitioner is only to retain 500 ration cards along with the authorization of the petitioner, which would not entitle the petitioner to challenge any notification for establishment of any other fair price shop as regard the remaining ration card holders. In that view of the matter, I do not find any infirmity in the order passed in the notification which has been issued. As such, I pass the following order. Writ petition is dismissed. Respondents are, however, directed not to reduce the number of ration cards of the petitioner below the minimum guaranteed number of 500.
Great.
A1 of 25 is allowed.
26.
F of the
Prasanna Vyas.
petition, my lords, annexure A, my lord, is the impugned proceedings. Appointing an administrator to the temple, my lords. I am concerned with item number 3, my lords, page number 15. Item number 3, my lords, annexure A. It is an order passed by the ex officio secretary Jilla Dharmika Parishad, my lords, invoking section 29 of the HRI Act, my lords, appointing an administrator to the temple, my lords, where the petition is a hereditary trustee and archak. My lords, such an attempt was made earlier also in the year 2016. There was an interim order, an appeal was filed, and repetition also filed. But those appeal and repetitions were disposed of, having become infructuous because not those term of 3 years has been expired. Now, my lord, suddenly.
What is it? What is there to show that this hereditary archer?
My lord, there are proceedings, my lords, before the civil court. My lords, this particular temple, my lord, is in my ownership property. My lord, survey number 41 bar. Please, my lords, kindly see, my lords. My lord, annexure G, my lords. My lord, in the 1983, my lords, there was a partition deed in the family. In the year 1983 itself, my lords, page number 28, my lords, annexure C. Annexure C, page number 28. Para number 3, my lords. A sale deed was executed in favor of the predecessor of the petitioner, in which my lord, Sadri Kraya Cheetu Prakara, Sadri Astiyalliruva Subramanya Devara Pujadi Vinyogagalanu ಅವರ ಮನೆ ದೇವರಾದ ದುರ್ಗಾ ಪರಮೇಶ್ವರಿ ದೇವರ ನಿತ್ಯ ಪೂಜೆ ವಿನಿಯೋಗಗಳನ್ನು ನಡೆಸಿಕೊಂಡು ಬರಬೇಕೆಂದು ಷರತ್ತು ಇರುತ್ತದೆ. ಸದರಿ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನಕ್ಕೆ ಸರ್ಕಾರದಿಂದ ಸಾಲಿಯಾನ ನಗದು ರೂಪಾಯಿ 28 ತಸ್ತೀಕ್ ನಡೆದು ಬರುತ್ತಿದ್ದರು. ಮೊದಲು ಸದರಿ ದೇವಾಲಯ ಕೂಡ ಸದರಿ ಲಕ್ಷ್ಮೀ ನರಸಿಂಹಣ್ಣ ನಾರಾಯಣ ರಾವ್ ಅವರ ಸ್ವಂತ ದೇವಾಲಯವಾಗಿದ್ದು, ನಂತರ ಅವರ ಕ್ರಯಚೀಟು ಷರತ್ತ ಪ್ರಕಾರ ನಮ್ಮ
ವಿಭಾಗ ಪತ್ರ between all of you.
Please note.
This is a private document.
Yes.
There is a public document indicating that to say.
Lord, there is no public document to show that this temple belongs to the government. Even in
Notify agilva.
ನೋಟಿಫೈ ಲೇಟರ್ ಆಯ್ತು 1997 ಆಕ್ಟ್ ಪ್ರಕಾರ ನೋಟಿಫೈ ಆಯ್ತು ಸೆಕ್ಷನ್ 25 ಪ್ರಕಾರ. Then my lords, I made an application before the Rajya Dharmika Parishad to declare me as hereditary trustee. And also, my lord, I have called in question the order annexure H, my lords. Kindly
So
see annexure
you
H.
gave up a right on the private temple and only you asked.
Yes,
for
it is
hereditary
only a private temple, my lords, administered by me and my father, my grandfather. There was a civil proceedings in which, my lords, a partition was taken place, and this particular property, survey number 41/1, was allotted to my share, in which, my lords,
Yes.
ಇಲ್ಲ ಕಮಿಟಿಗೆ ಸ್ಟೇ ಆಗಿದೆ, ಸ್ಟೇ ಆಗಿತ್ತು ಅದು ಟರ್ಮ್. ಹೌದು.
And they have been discharging their role. Committee has been discharging its role.
ಇಲ್ಲ ಸ್ಟೇ ಆಗಿತ್ತು. I have produced the stay also, my lords. Kindly see, my lords. Page number annexure H.
Did it take over the administration?
No.
If not
Annexure
taken
H, your
over,
lords may
don't
kindly.
take it over now. And AGA accepts notice for respond number 1 to 3. Not taken. The respond number 3 is restrained from taking over the management of the subject temple if not already taken over by him or by the committee previously appointed. Relist on 12th November. In the meanwhile, objections to be filed by the respondents, which shall be so filed on or before 4th November.
Please, update.
27, Satish DS.
Related payment of allotment price, my lords.
Cancellation.
KDB allotted it. I have not paid the amount within time. Therefore, the cancellation order is issued as per annexure E.
I need to seek instruction, my lord, to take notice for HL
They
Pradeep.
pay. You are appearing for whom?
For HL Pradeep Kumar, will take notice for R 2, 3 and 4, my lord.
And AGA accepts notice for respond number 1. CH-12 Pradeep Kumar accepts notice for respond number 2 to 4. He seeks for and is granted 10 days time to obtain instruction, make his submission. Relist on 11th November.
Obliged.
Seek for an interim order. Possession certificate issued,
You are in
allotment.
possession.
And possession certificate issued, allotment is confirmed.
Respondents are restrained from disposing the petitioner if not already disposed. IA 1 of 25 is allowed.
28, Shamsawar.
I appear for the petition in this, my lords.
Yes, Santosh.
My lords, the petitioner is a tenant, my lords, with the correspondent corporation, my lords, running a restaurant. My lords, sought for an extension of another 5 years term, my lords, by letter to my lords. Annexure C, my lords. And annexure D and E, my lords, have been issued, my lords, on the same day. Lords, wherein my lords have been due an amount of rupees 14,10,221. And then detailed order, detailed notice has been issued, my lords, so styling it as a final notice, stating that I have been due 4 months due in the year 2021 and 3 months due in the year 2025, my lords. These 4 months due, my lords, in the year 2021 were also been notified, my lords, to me by annexure B2, my lords, at page 22.
You are due of 14,10,221.
Please, my lords. My lords, in this, my lords, with regards to this, the due of April 2021 and May 2021 and June 2021, my lords, for the 3 months, my lords, there was an exemption awarded by the corporation, my lords, which was later withdrawn, my lords. I have paid a part of the amounts when the corporation had provided exemptions in the COVID periods.
Nim prakara 2 ತಿಂಗಳು ಬಾಕಿ.
No. My lords, I'm ready to deposit, my lords. Even the July, my lords, has been paid in the month of August, my lords.
10 lakhs you have to deposit. 10 lakhs is the
Please.
difference.
Please, my lords. I may be permitted, my lords. I will pay, my lords, subject, my lords, that they have issued the final notice and also they are issuing.
When will you deposit 10 lakhs?
My lords, at 2 weeks' time will be getting, my lords, in 2 installments, part of the, my lords, and another 2 weeks I'll pay the other 50%, my lords.
KSRTC arama? The BLs. BL Sanjeev is directed to accept notice for respond number 1 and 2. The learned counsel for the petitioner submits that given 2 weeks' time, 10 lakh of rupees would be paid to the respondents as regards the pending arrears of rentals. In that view of the matter, respondents are restrained from dispossessing the petitioner if the till the next date. If the amounts are not paid by 30th October, the interim order will stand automatically vacated.
That's 2 weeks, 50%, 2 weeks, months, another 50%, 2 weeks, months.
2 weeks,
Totally 4 weeks.
5 lakhs by 30th October, 5 lakhs by 13th November. If there is default in payment of any of the amounts, the interim order will stand automatically vacated.
29.
Recreation club, my lord. Recreation club.
And AGA accepts notice for respond number 1 to 5. She seeks for and is granted 2 weeks' time to obtain instruction as regards whether the petitioner recreation club has been functioning and has been functioning properly.
It's functioning, my lord.
ಗೊತ್ತಿಲ್ಲ ಇವಾಗ ಎಲ್ಲ ಹಂಗೆ ಬರ್ತಾ ಇದಾವೆ ಏನಕ್ಕೆ ಆಗ್ತಾ ಇದೀರ ಅಂತಾನು ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ಇನ್ನ when they are not functioning ಖಾಲಿ ಜಾಗಕ್ಕೆ petition ಹಾಕಿ ಆರ್ಡರ್ ತಗೊಂಡು ಸುಮ್ಮನೆ ಇದ್ರೆ ಏನಕ್ಕೆ ಅಂತ
My case is concerned, it is functioning.
11th released on 11/11.
In fresh matters list.
The full batch, it will come in a separate list at 2:30. At 2:30 PM ಅಂತ ಹಾಕೊಳ್ಳಿ ಅದನ್ನೆಲ್ಲ ಇವೆಲ್ಲ ಬ್ಯಾಚ್ ಏನಿದೆ 25th ಬ್ಯಾಚ್ ಇದೆಲ್ಲ 2:30 ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಬಿಡಿ 29th ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಬಿಡಿ ಡಿಫ್ರೀಸಿಂಗು ಸಪರೇಟ್ ಲಿಸ್ಟ್ 2:30 ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಇಲ್ಲ ಇದು ಮಿಕ್ಸ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ರೆ ಎಲ್ಲಿ ಯಾವುದಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ.
30. Dharmapal.
For the petition, my lord, petitioner, he is a tenant running a hotel. And there was a threat of eviction, forcible eviction. He has filed a suit for an order of injunction and obtained temporary injunction. The ink page number 23, my lord. Defendant number 1, 2, 3 are hereby restrained from dispossessing plaintiff from suit property. Now, after the getting the order, the respond number 7, 8 and 9 forcibly they have taken all the materials, they removed forcibly and they restrained.
You are in possession or you are not in possession?
I am in possession. I am in a position, but they are not allowing me to run the hotel. Even extension ಕೂಡ ಆಗಿದೆ.
You have to get orders from that court.
ಅಲ್ಲ ನನಗೆ ಇದರಲ್ಲಿ ಅಲ್ಲಿ ಕೋರ್ಟ್ಗೆ ನಾನು ಹಾಕಿದ್ದೀನಿ. There is no use of on 20 page number 24 ಅಲ್ಲಿ 280 complaint ಕೊಟ್ಟೆ, complaint deputy commissioner of police and they have not taken action, and 28 they have issued.
So this is a complaint.
Complaint, they have received a complaint, they issued the endorsement, but they have not given any protection to me to run the hotel. Now he is under the threat. Near about 4 lakh material he has removed.
For a tenant again under respond number
earlier 8 and 9. Now what are the respond number 7, Salim, he says that he has purchased the hotel building. And now he is in charge of that building. What he says that now he has removed all the materials, the kitchen items and table, chair and everything from the hotel. And they have not
ex parte interim order was only not to interfere with your possession. Now you are saying it's been interfered with.
They have interfered with it. They are all, I am in a position and they are troubling and
file a 39(2)(a) there.
That will take years, that will take months together, my lord. Now the
immediate police protection to
immediate action is police protection to run the hotel. That's all.
Get an order from the trial court for running the hotel. Your order right now, which they can implement, is interference. Interference has already happened.
Interference, he is not in position. He is not in position. Now I am in the position. Now I am in the position. They are interfering with my peaceful position. And they are not allowing me to run the hotel. That's all. Now they have not taken the position of the hotel.
Mr. Counsel,
yes, my
lord. Third and last time we'll tell you. There is no order of the trial court permitting you to run the hotel for the police to do that.
They are not interfering. They shall not interfere.
AG accepts notice for respond number 1 to 5.
Restrained from dispossessing.
1 to 6. issue notice to respond number 7 to 9, returnable by 27th
No, till
November.
then, my lord, the police may be,
Not at all.
ಅಲ್ಲ ಅಲ್ಲ ಅಲ್ಲಿ ಅವ ಇಲ್ಲ ನನಗೆ ನಾಳೆಯಿಂದ even ಅದನ್ನ at least
Notice
direction.
to so and so is dispensed with the new of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. Essentially, the petitioner is seeking for a mandamus to the police to provide police protection to implement the ex parte order of injunction dated 1/8/2025 passed in OS number 5575
55.
of 2025. The said order reads as under page 23. The submission of learned counsel for the petitioner is that post the said order, respond number 8 year in, 7 year.
ಅಲ್ಲ seven.
7 year in has interfered with the possession of the petitioner and removed the equipment of the petitioner and not permitting the petitioner to run the business of a hotel in the subject premises. A perusal of the above extracted interim order is only relates to grant of an injunction restraining interference with the possession of the petitioner, which possession apparently has already been interfered with. In that view of the matter, the petitioner would have to make necessary applications in the pending proceedings for violation of the said order. Insofar as grant of police protection to run his hotel business, there is no particular order which had been passed by a trial court in that regard. And as said, the police cannot be directed to permit and protect the petitioner in running the hotel business. It is however open to the petitioner to move the trial court.
Consider my application if filed before the
It's
trial.
however open to the petitioner to file necessary application before the trial court for appropriate relief, which shall be considered in accordance with merit.
31. Ranganatha.
31.
Writ of mandamus to
DG, Election Commissioner. Shri Pawan Kumar is directed to accept notice for respond number 2 and 3. Election Commissioner Yarama?
Yes, sir, don't worry.
That word for 1, 4 and 5. Yavatida avela?
25th.
25th.
Great.
The list on 25th.
32.
The petitioner, my lords, serving sentence on since 20 years, my lords, 20 years. Earlier, this honorable court has granted parole with the direction to the government to consider his premature release, which is at page number 33, my lords, the order, my lords. Thereafter, my lords, the LCRC has been considered.
Premature release.
Yes, my lords, premature
And
release.
AG accepts notice for respond number 1 to 4, released on 29th October.
Obliging.
Idonu 29th October at 2:30 PM. Full connected.
Obliging.
33.
For petitioner, my lord, questioning the perjury proceedings, my lord, read with 482, my lords, there. Annexure is the
Perjury proceedings.
My lords, in a civil suit, my lord, an application is filed. To application, lords, is filed at annexure F, page 75. Lord, based on this, my lord, the learned trial court said, my lord, let there be a separate inquiry. Directed, registered a case. No, my lord, no complaint, my lord, no opinion is formed, my lord, as to the perjury proceedings has to be conducted separately. Annexure is the order sheet, my lord, initially first date. No cognizance is taken, my lord, no FIR, no complaint, no formal complaint by the court has been filed. Without nothing, my lord, no proceeding in the matter. No.
Well, where is the particular order dated?
It's the order, lords, is found at annexure H, my lord.
Annexure H, PO transferred, call on.
It's J, my lord, I'm sorry, 92. And on next, my lord, and next year K, my lord, there is another tariff.
There's an application 195 and 340 which have been
Yes, my lord.
filed.
On that, my lord, annexure K 93, my lord, there is a direction to hold an inquiry on that application regarding the perjury proceedings.
To that, my lord, as per section 195, my lord, there has to be formal complaint by the court, my lord. Only on that complaint, my lord, the investigation inquiry can be held.
ಇವಾಗ ಯಾರು ರಿಜಿಸ್ಟರ್ ಮಾಡಿರೋದು ಇವಾಗ?
Let's see, it's a register against petitioner and one another, my lord, who is against him, my lord, the respondent said he will not prosecute.
195 and 340 ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ?
Agilla, my lord. They said they will hold a separate inquiry anta. And my lord, the same court is conducting the matter, my lord, which he cannot be done. The allegation,
where is that order?
But order model, just there was submission by the councils saying that there has to be a separate inquiry madi anta. So the court said we'll hold a separate inquiry.
Yes.
To hold that, my lord, section 195 CRPC says, my lord, the court has to register a complaint, my lords. Only then, my lord, the CMS proceedings can be done.
Both the councils have said they have
Inquiry
no
can be held, my lord. We say let the inquiry. To hold an inquiry, my lord, the court has to prima facie form that whether they.
ಏನಕ್ಕೆ ನೀವು ಇಬ್ರು ಹೇಳಿದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಮೇಲೆ
Please.
an application has been filed on 195 and 340.
Please.
Both the councils say let there be an inquiry.
Please, my lord, but there has to be a complaint, my lord. That is, my lord, we said, my lord, we said on that, my lord, there has to be a complaint, my
That
lord.
195 application will be the complaint.
My lord, that is not. But even cognizance to the annex here is the order sheet, my lord. Page 1414. Cognizance to the my lord. Frame charges to frame madilla. Page 14. Column 8-9, my lords.
Regarding maintainability, you have argued.
Please, it was argued, my lord, because there is a suit, it cannot go on, my lords. Now regarding the cognizance and also another bar is the same court, my lord, on which there is an allegation.
All these contention you are raising has already been argued and it's been rejected.
But the contention regarding, my lord, was only with when the suit is there, my lord, it cannot go. The proceedings cannot go. No, my lord, without taking the cognizance, my lord, the proceedings cannot go, my lord. There's one judgment and I missed it, my lord. It could be passed or I'll just get the judgment. Without cognizance, my lord, it cannot proceed. And also, my lord, the court in which
that could be a situation where you have objected to it. You have consented here.
Lord,
You yourself said it, let it be registered.
Let's say it's a one mistake from the counterpart, but my lord, the formal procedure.
You challenge that order. Until that order is there, none of it can be found fault with.
But what has happened, my lord, that plaint was rejected. Now it's been stayed before the Honorable Supreme Court, my lord. Now,
That is all different.
please, my lord.
We are not concerned with your merits of the matter or ಏನ್ ಮಾಡಿದೀರಾ ಅಂತ. Then application 194, 340 was filed.
Please.
Both the council said refer it, register as CMS.
Please.
Order has been passed. CMS has been registered. Inquiry is happening.
My lord, that
Is that your instance?
That, my lord, let the inquiry may go on, but cognizance, my lord, without taking cognizance is important. My lord, on 209, cognizance is not taken. When I admit, my lord, let there be an inquiry. To hold an inquiry, my lord, ultimately, if these proceedings are concluded, we will be saying, my lord, I have committed a mistake of perjury on 209. To hold that, my lord, there has to be cognizance and charges has to be framed on.
Charges have to be framed.
Please, my lord, that has not been done. The procedure.
Direct the trial court to do that.
Please.
Notice to respondent is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. A suit in OS number
And also,
488 of 2019 has been filed. In the said suit, an application under section 195 read with 340 and IA number 2 and 5 had been filed. When the matter had been taken up for hearing on 6/7/2021, both the councils submitted that a separate CMS would have to be registered, in persons of which the trial court directed the registration of such a case, and as such, CMS number 40 of 2021 came to be registered. The only grievance of the petitioner for now is that without taking cognizance and without framing charges, an inquiry is proposed to be held by the Principal Senior Civil Judge and CJM Tumkur. And as such, the interest of the petitioner would be adversely affected. The proceeding in CMS being criminal in nature, it is but required that cognizance of the alleged offences is taken and charges framed. A peril of the order sheet would only indicate that orders have been passed on maintainability, application for
Recalling PW.
recalling of witness ಆಗೋಗಿದೆಯಾ?
ಅದು ಒಂದು recalling ಆಗಿದೆ.
Evidence ಶುರು ಆಗಿದೆಯಾ?
No sir, without evidence, my lords. ಇವಾಗ evidence ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ. Notice today is the matter, my lord, for cross of PR.
Then we'll have to state. Issue notice to the respondent returnable by 12th November. The further proceeding in criminal misdemeanors number 40 of 2021 pending on the file of the additional senior civil judge and CJM Tumkur is stayed till the next date of hearing. Process fee and copies to be furnished by end of date tomorrow. Acknowledgement of service on the counsel for a respondent before the trial court to be filed by end of day 31st October. Failing either of which, the interim order will stand automatically vacated.
Obliged.
34, Pradeep Patil.
Hello, this petition for general parole on son's health condition.
Sons?
On page number 9 is the endorsement given by the hospital. First time he is opting for parole.
Yes, madam. And AG accepts notice for respondent number 1 to 3. ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು ಇದು?
My lord,
Who has filed this petition? ನೀವು ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಮೊನ್ನೆನೂ ಅದೇ ಮಾಡಿದ್ರಿ.
is a wife of the petitioner, petitioner convict.
So who has filed this petition?
Wife of the convict. my lord.
ಕಾಸ್ಟ್ ಟೈಟಲ್ ನೋಡಿ.
I'll rectify it.
ಮೊನ್ನೆನೂ ಅದೇ ಹೇಳಿದೆ.
I'll not repeat this mistake next time.
The wife of Srinivas V, CTP number 754, who is lodged in the Mysore Central Prison. He is before this court seeking for general parole for the first time in respect of said convict. ಏನಕ್ಕೆ? What is the reason?
On son's illness, my lord, annexed at page number 9.
On account of the illness of the son of the petitioner and the convict. In support thereof, a medical certificate issued by the Government General Hospital, Yelahanka, dated 8/10/2025 has been produced. Stating that the said son is suffering from congenital proximal myopathy and early onset of limb girdle muscular dystrophy, requiring immediate medical attention on account of muscle wasting and discrepancy in the muscle bulk. The said application having been for parole having been filed had not been considered. In rejection ಏನು ಇಲ್ಲ.
At page number 10, my lord.
Has been rejected on the ground of adverse police report. A perusal of the adverse police report only indicates the reason why the convict was prosecuted and the conviction conviction order which had been passed, namely that in SC number 235 of 2019 for offences under section 302 and 201 of the IPC with a sentence imposed for imprisonment for life. There is no particular reason found in the said police report as to whether the release of the petitioner on parole would cause any adverse impact in the society at large. The imprisonment certificate which has been issued indicates the conduct of the convict to be satisfactory in the jail, and there are no particular complaints as against the petitioner, who has already served imprisonment for a period of 2 years, 8 months, 29 days. In that view of the matter, I pass the following order. Petition is allowed. In the above circumstance, it's very clear that there are no particular reasons to deprive the convict of parole, of general parole, when there is a clear and categorical reason made out of the convict's son's illness requiring medical treatment, which aspect has not been considered by the respondents in the order dated 26/9/2025 rejecting the parole application. In the above circumstance, I pass the following order. He is allowed released on so and so for 60 days, usual conditions so and so.
35.
RJ to forward, government advocate to inform.
In this case, your lordship, I can see that the Karnataka government is discriminating to release the funds in respect of Srinivaspura Taluk, my lord.
Release the amounts in favor of Srinivaspura Caste. PAL ಆಗ್ಬೇಕು ಇದು.
ಅಲ್ಲ ಬೇರೆ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ your lordship
ನಿಮ್ಗೆ ಏನಾದ್ರು ರಿಲೀಸ್ ಮಾಡ್ಬೇಕಾ ಹೇಳಿ.
ನಮ್ಗೆ
ಶ್ರೀನಿವಾಸಪುರ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಅಲ್ಲ, ಶ್ರೀ ವೆಂಕಟ ಶಿವ ರೆಡ್ಡಿಗೆ ಅಂದ್ರೆ ಹೇಳ್ಬೋದು.
ಅಲ್ಲ ವೆಂಕಟೇಶ್ವರ ರೆಡ್ಡಿ ಇದು ಸಿಟಿಂಗ್ ಎಮ್ಎಲ್ಎ ಆಫ್ ದಟ್ ತಾಲೂಕ್.
PIL.
ಅಲ್ಲ PIL ಅಲ್ಲ, ಇದು ಬರೋದಿಲ್ಲ. ಇದು ಶ್ರೀನಿವಾಸಪುರಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದಾನೆ, ಎಲ್ರಿಗೂ ಎಂಟೈರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ಸ್ಟೇಟ್ ಕೇಳ್ತಾ ಇಲ್ಲ.
You are asking for and on behalf of the constituency.
Oh yes. ಅಲ್ಲ your lordship can say annexure J.
What are the funds, Mr. Reddy?
Annexure J, your lordship can see how they are discriminated.
The fund, ಏನ್ funds ಇದು ಅಂತ?
Funds ಎಲ್ಲ chief minister fund. From 2019 till today, my lord, the chief minister is directed to release the amount. So far, they have not released the amount. Just your lordship to page 41, annexure J. Here your lordship can see the persons who are elected from the Congress at KGF, Bangarpet, Malur and Kola, sanctioned for 50 crores. Then your lordship can see next page, my lord, annexure K, my lord. Discriminating and granted only 25 crores to Srinivaspura Taluk. Here your lordship can see this amount was also not released. Even Malur, this Mudabagal, where Janata Dal MLA is there, there also 25 lakhs. The only Congress MLAs, 25 crores, 50 crores.
What is the personal list in this matter?
Because I am a representative of this constituency, because for that, my lord, even your lordship may kindly see the question of our annexure E, my lord. I have raised the point in the assembly.
You are filing it in a representative capacity.
Yes.
You'll have to file it as a PIL, not as a private interest litigation.
PIL
ನಿಮ್ ಜೇಬ್ಗೆ ಏನ್ ದುಡ್ಡು ಬರಲ್ಲ ಇದು.
ನಮಗ್ ಬೇಡ.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು, PIL ಹೋಗ್ಬೇಕು.
Why the people that elected me to
ಇವಾಗ ಇದನ್ನ ಕನ್ವರ್ಟ್ ಮಾಡ್ಬೇಕಾ ಇಲ್ಲ ಫ್ರೆಶ್ ಪೆಟಿಷನ್ ಹಾಕ್ತೀರಾ?
ಇಲ್ಲ ಕನ್ವರ್ಟ್ ಮಾಡಕ್ಕೆಲ್ಲ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಆಗ್ಬೇಕು.
ಬಹಳ ಕಷ್ಟ ಆಗತ್ತೆ.
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಎಲ್ಲ
ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಿ.
Even one moment, your lordship can say annexure E, your lordship can say.
ಏನ್ ನೋಡಿದ್ರೆ it's not our jurisdiction roster. ಏನು ಆರ್ಡರ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ನೋಟಿಸ್ let them say how we are discriminating.
ಹೇಳಿ ದುಡ್ಡು ಕೊಡುವಿ ಅಂತ ಹೇಳ್ಬೋದು ಅಷ್ಟೇ. ಆರ್ಡರ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಕೊಡಬೇಡಿ ಅಂತಲ್ಲ,
ಕೊಡಿ ಅಂತ ಹೇಳ್ಬೋದು ಅಂತ, ಬಟ್ ಆರ್ಡರ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್ ಯಾಕೆ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ ಅವ್ರ ಗವರ್ಮೆಂಟ್ ಅಷ್ಟು ಸಾಕು.
PIL, because you are representative capacity. And AG accepts notice for respond number 1 to 5 ZP.
Even your lordship can say the Supreme Court, my lord, the Karnataka government has filed a petition. It is not a public interest. Karnataka government has filed a writ petition before the Supreme Court seeking discrimination by the central government. Notice has been issued.
Supreme Court ಅಲ್ಲಿ Karnataka government filing is different. You are a MLA in a representative capacity. Government ಗೆ ಹೋಗುತ್ತೆ ದುಡ್ಡು.
ಅದು ಗವರ್ಮೆಂಟ್ ಇಂದ ಗವರ್ಮೆಂಟ್
ಬರಲ್ಲ, ಅದು ಗವರ್ಮೆಂಟ್ ಜೇಬಿಗೆ ಹೋಗುತ್ತೆ ಅದು. Then they have to do
ನಮ್ಮ ಜಾಬ್ಗೆ ಬೇಡ, ನಮ್ಮ ಗವರ್ಮೆಂಟ್ ನಮ್ಮ ಫಂಡ್ಸ್ ಗೆ ಡೆವಲಪ್ಮೆಂಟ್ ವರ್ಕ್ಸ್ ಕೊಟ್ರೆ ಸಾಕು ಅಂತ.
ನಮ್ ರೀಸನ್ ಆರ್ಡರ್ ಬೇಕಾ, ನೀವು ವಿಡ್ರಾ ಮಾಡಿ ಫೈಲ್ ಮಾಡ್ತೀರಾ? ಎರಡರಲ್ಲಿ ಹೇಳಿ. ನಿಮ್ಮಿಷ್ಟ ಏನ್ ಹೇಳ್ತೀರಾ ಅದ್ ಮಾಡ್ತೀವಿ.
Permit me to file this public.
He is before this court seeking for the following. After arguing for some time, the senior counsel seeks for permission to withdraw the above petition with liberty to file a public interest litigation.
Please.
Reserving such liberty, petition stands disposed. The roster issue has become a big matter. If you don't have a roster, don't touch it.
36.
For petitioner, my lords. Here, my lords, we are challenging the government order, my lords, where the recommendation has been set aside by the government, my lords. And I have
By
filed it.
Lokayukta. And AGA accepts notice for respond number 1. Issue notice to respond number 2 and 3,
My lords, I have-
returnable by 19th November.
I have filed IF for dispensation, my lords, of
Okay.
certified copy, because my lords, we have to.
Hey,
Certificate of
1 of
government order, my
25 is
lords.
allowed. Notice dispensation in.
No, no, please, my
1 of 25 is allowed.
please, my.
37. Ashoka T.
My lords, in this case, I'm for petitioner. In respect of the property in question, my lords, there are 8 cases are pending in Dodbalapura, my lords. The respond number 3, police is interfering with the property, my lords. He says that he will decide the position, my lords.
Why are so many matters coming like this, madam? And AGA accepts notice for respond number 1 to 3. Since there are serious allegation made against respond number 3, respond number 3 is direct file an affidavit in that regard. Released on 30th October.
My lords, there is interim prayer till then, not to interfere with.
Respondent number 3, he is directed not to interfere with the possession of the petitioner unless otherwise authorized under law.
Much obliged.
38.
Yes, Mr. Abhinay.
Waqf board has directed, my lords, may kindly come to page 60, my lord.
To speed up the enrollment, to install managing committee without changing administrator.
August 25.
Who are you?
My lord, I was one of the interested persons, my lord, the petitioner before the Waqf board.
You are not the administrator.
I'm not the administrator.
You are not part of the advisory committee.
My lord, I
You
am
are
the
not
person who
advisory-
filed the petition under 83(2).
But you are not the administrator or advisory committee. Only
Only
they can be aggrieved.
My lord, the direction is, my lords, must see. Right.
Page
60, my lord. Application find under 83(2) is allowed. R1 is directed to take necessary action to
What is
verify the list
R1?
of members. I was the
R1 is
petition
the
before, my
Waqf
lords, at page
board.
49.
Hmm.
R1 is directed to take necessary action to verify the list of members of the general body of respondent number 2 as to whether any non-resident of Bangalore metropolitan is inducted as a member and to exclude such eligible members. My lord, this Waqf board, Waqf institution, my lord, is under the institution and the administration of the administrator from last 4 years. They don't do anything. They don't even complete the list. Now it is still continuing under. Therefore, my lord, I had filed the petition at page 49. My lord, I am the petitioner before the Waqf tribunal. Since this order can't be enforced, my lord, under 83(7) before the civil court, I am left with no other remedy. Having obtained the order, I stand without an order.
You have remedy. We can't advise you on that. But this is not the remedy. You are saying from changing the administrator. What is the point in that?
I'm not, they will have to finance the list. I'm not on the administrator. The list will have to be finalized. The direction, my lord, is for
Your
the-
interim relief, ಅದು.
Yes,
Sorry,
that was an interim relief. That
Interim
cannot-
relief cannot be granted.
That cannot be granted.
ಮತ್ತೆ ಯಾಕೆ ಕೇಳ್ತೀರಾ? Waqf board ಯಾರು? Accepts notice for respond number 1 and 2. Who is respond number 3?
Lord, it's the Waqf institution, my lord, administrator, state government only, administrator is by the state.
But you made him as a party in this person.
Yes, my lord, and before the tribunal, my lord, on Mahadevaya I had represented, my lords may permit me to serve notice on KB Mahadevaya.
Shri?
Page 49, my lord, KB Mahadevaya.
Shri KV Mahadevaya, who had appeared for respond number 3 before the Waqf tribunal, is directed to accept notice for respond number 3. The counsel for respond number 1 and 2 is directed to obtain instruction and make her submission as to by when the order dated 30th August 2025 would be complied with. Released on 3rd October and 3rd November.
Great.
39.
My lords, in this matter, I am Archak, my lords. There were enquiries against my father, my lords. He passed away. The enquiry was closed due to abate, my lords. In the order of writ appeal, my lords, in page number 29, I was directed.
So you given a representation for you to be appointed.
Please, my lords, I have made a representation in terms of the observation, my lords.
ಯಾರು? Endowment, religious endowment. Sir, ಮಾಡಿಲ್ವಾ? ಯಾಕಪ್ಪ ಮಾಡಿಲ್ಲ?
ಮಾಡ್ತೀನಿ, my lords.
It's only a mandamus.
Mandamus.
Lord AG access notice for respond number 1 to 4. The grievance of the petitioner is that after the expiry of his father, the petitioner application for being appointed to the post of Archaka wide representation dated 22/9/2025 at Annexure A is yet to be considered.
A and B, my lords.
B, ಏನು?
B to Tahsildar, my lords.
Prayer ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ. Whenever any representation or application is submitted, it is required for the official respondents to consider the same and pass necessary orders within a reasonable period of time, either accepting or rejecting the application. Neither having been done, I pass the following order. Writ petition is partly allowed. A mandamus is issued directing third respondent to consider the representation of the petitioner dated 22/9/2025 at Annexure A and pass necessary orders within a period of 4 weeks from the date of receipt of a copy of this order.
Much
made clear that this court has not expressed any opinion on the merits of the matter.
Much of.
40. Satish Kumar.
Please, a writ of mandamus.
Yes.
Directing the second respondent, my lord, to consider the complaint. That the petitioner before lordship, my lord, is one of a defendant in a suit or a partition which has been filed, my lord, wherein the fourth respondent is also a defendant therein. Lord, after the suit was instituted in the year, in the month
The
of.
fifth matter today, madam. And AG accepts notice for respondent number.
May I make one request?
1 to 3, issue emergent notice to respondent number 4, returnable by 11th November. Interim prayer ಕೇಳಿಲ್ಲ?
24, my lord, huh?
You're not asked for any interim relief.
Let them maintain status quo, not.
You're not even asked for it. We are ready to give it, you are not asked for it.
Lordship may mold the relief. Because
Mold
only one request, your lordship may kindly bear with me for a moment. In fact, the suit was, yes, my lord, I do understand.
We can mold if you ask. If you don't ask, we can't mold anything.
I do agree.
There's
I'm
nothing
sorry.
to mold. Respondent number 3 is directed to file an affidavit as regard the serious allegations made by the petitioner in the present matter by the next date of hearing.
Lordship may have it on 7th, my lord.
11th.
But I'll.
Respond
Speak
number,
from Madurai.
there being several matters which are coming up before this court, making similar allegations against the police authorities of their interference in civil matters. Respond number 2 is directed to look into the same and file an affidavit as regards the actions that are proposed to be taken by respond number 2, including suitable directions and penalty provisions to be imposed if such complaints are received by next date. Our jurisdiction ಅಲ್ಲ ಇದೆಲ್ಲ ಆಗ್ತಾ ಇರೋದು. ಸದ್ಯಕ್ಕೆ ಬರೀ ಬೆಂಗಳೂರು. There are so many complaints which are coming. Please understand, nobody will. Please also understand, nobody will come before this court and make this allegation against police officer. ಆಮೇಲೆ ಅವ್ರಿಗೆ ಅಲ್ಲಿ ಬೆಂಡ್ ಎತ್ತಾರೆ. Let him look into it and issue necessary
I have
direction.
it on the 7th, my lord. 7th, I'm coming from Madurai.
11th, you are not there?
But I'll have a matter on the 7th.
12th.
7th, my lord.
7th is CMP day, so we can't have.
I'll leave it to your lordship. Then 11th, my lord, I'll come. Much obliged.
41. Pratap SS.
My lord, agenda for 90 days on father's illness. My lord. Father's illness.
ಇಷ್ಟೊಂದು ಏನು ಇಲ್ನೆಸ್ ಏನು?
ಅಲ್ಲ, insist my laws to direct ಈ ತರ ಹೆಲ್ತ್ ಗ್ರೀವೆನ್ಸ್ ಇದ್ರೆ ಅಲ್ಲೇ ಒಂದು ಗ್ರೀವೆನ್ಸ್ ಬಾಕ್ಸ್ ಇಟ್ಬಿಟ್ಟು they should be considered.
ಅಲ್ಲ ಏನು ಇಲ್ನೆಸ್ ಏನಪ್ಪ?
His father is suffering from.
What have you produced?
I produced a medical report at page number 9, my lord. He's suffering from 3 years, my lord. And once the petitioner is out on emergency parole and endorsements.
Carcinoma, third stage. Liver.
Endorsement says ಒಂದ್ಸತಿ ಆಲ್ರೆಡಿ ಬಿಟ್ಟಿದ್ದಾರೆ ಇನ್ನು ಏನು ಗಲಾಟೆ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಾರೆ ಪೇಜ್ ನಂಬರ್
Liver
10
cancer, third stage, madam.
ಅಲ್ಲ ಇದು ಪೇಜ್ ನಂಬರ್ 10 is endorsement. Once on emergency parole, there is no conflict in the village also, they stated in last paragraph. 16/2/2020 ಗಣ್ಯ ನ್ಯಾಯಾಲಯ ಘೋಷಿಸಿದ ಜೀವಾವಧಿ ಗ್ರಾಮದಲ್ಲಿ ಹೋಗುವಾಗ ಪೆರೋಲ್ ಮೇಲೆ ರಜೆ ಬಂದು
Item number 5. Yes, ma'am. 30 days he has been released.
This is also filed by.
Who is Rakshita, wife of Naveen
Wife
Kumar?
of convict.
So wife. Wife of Shri Naveen Kumar LR. CTP number 01174 is before this court seeking for general parole of the convict on the ground that the father of the convict is suffering from third stage liver cancer, and as such it would be required for the petitioner to partake in his treatment to some extent before any untoward incident were to happen. The submission of counsel for the petitioner is that the petitioner had once earlier been released on general parole.
No, emergency parole.
Emergency parole for a period of 30 days.
15 days.
30 antide.
As imprisonment certificate shows 15 days.
ಅರ್ಜಿದಾರ ಮನವಿ ಅಂತ 30 ದಿನ parole.
Imprisonment certificate ಅಲ್ಲಿ 15 days ಅಂತಿದೆ. At page number 8, my lord.
For emergency parole on 15 days on an earlier occasion, and the petitioner and the convict has complied with all the conditions and there is no violation made by the convict. His submission is that if parole is granted this time, the convict would again comply with all the conditions. Considering that the father of the convict is suffering from liver cancer and that the convict had earlier been released on emergency parole, as regards which there is no particular complaint or allegation, and the conduct of the petitioner and the conduct of the convict has been found to be satisfactory, I am of the opinion that the petitioner can be released on emergency, on regular general parole for a period of 30 days. In that view of the matter, I pass the following orders.
I'll rectify it, my lord. Next time and all, I'll file in the name of affidavit.
Yaar petitioner bere.
I got the point.
You will be in trouble.
42, Dilip Kumar.
A simple prayer.
Simple.
Direct the respondent number 3 police to seize the container which is been used to subject matter of the crime number. An FIR has been registered, that is in page Malad 2222 for mischief, criminal trespass, criminal intimidation and unlawful assembly. The FIR has been registered. Malad,
investigation is going on.
Malad?
Investigation is going on.
Investigation is going on, but that container is not, they have not been seized by the police, which has been illegally kept. But this property.
Who are you?
I am the complainant, my lord. I am the complainant, I am the owner of the property. The accused persons filed a suit in the year 2014. The suit was dismissed with Caste, my lord. They also tried to take the possession with liberty of the court, that has also been dismissed. When they could not take the physical possession of the property, my lord, they wanted to take this physical possession by hook or crook. On 24/9/2025, they have brought the container in front of the property. They have kept with the help of the local gundas. That, my lord, the backside, the people, the who are residing, the employees, we cannot access because they have kept towards the road. The people who are staying there, they have no access because the whole container has been blocked. I've been repeatedly requesting the police to seize, but it has not been seized.
Get instruction, madam. And AG accepts notice for respondent number 1 to 3. She seeks for and is granted 10 days time to obtain instruction as to whether the container complained of in the present matter is a material object in the offense alleged, as also whether the CCTV footage has been taken into custody by the investigating officer. Released on 30th October.
43, Prithvi Odia.
Prithvi. And AGA accepts notice for respondent number 1 to 3. Seeks for 2 weeks time to obtain instruction, make submission. Released on 6th November.
44, Manjunatha S.
My lord, I am appearing for the petitioner in this case. My lord, the petitioner belongs to Nayaka caste. My lord, in the year 1994, my lord, he has been elected as a Gram Panchayati member and also elected as a president. My lord, some of the members in the Panchayat have raised an objection saying that he is not belongs to a Nayaka community. My lord, a complaint has been lodged before the Assistant Commissioner and the inquiry was conducted as per the annexure C, my lord. Your lordship may kindly see the annexure C, my lord. At page number 19, my lord, para 2. ಎದುರುದಾರರು ಕೆಲವೊಂದು ರೆವಿನ್ಯೂ ದಾಖಲೆಗಳನ್ನು ಅಂದರೆ ಸಂಬಂಧಪಟ್ಟ ಕೈಪತ್ರ ದಾನಪತ್ರಗಳನ್ನು ಹಾಜರುಪಡಿಸಿ ಸದರಿ ಪತ್ರಗಳಲ್ಲಿ ಅವರ ಪೂರ್ವಜರು ಅಂದರೆ ತಂದೆ ತಾತ ಅಜ್ಜಿಯವರು ವಾಲ್ಮೀಕಿ ಮತಸ್ಥರು ಹಾಗೂ ಬೇಡರ ಜಾತಿ ಎಂಬುದಾದ್ರಿಂದ ಈ ಪಂಗಡಗಳನ್ನು ನಾಯಕ ಜಾತಿ ಅಂತಲೂ ಕರೆಯುವುದೆಂದು ಅವರ ತಮ್ಮಂದಿರ ಮಕ್ಕಳು ಓದಿರುವ ಶಾಲೆಯಲ್ಲಿ ಟಿಸಿ ಸರ್ಟಿಫಿಕೇಟ್ಗಳು ಸಹ ನಾಯಕ ಎಂಬುದಾಗಿರೋದ್ರಿಂದ ನಾಯಕ ಜಾತಿ ಸೇರಿದವರಾಗಿ ಈ ಹಿಂದೆ 1987ರಲ್ಲಿಯೇ ಎಸ್ಟಿ ಪತ್ರ ಹಾಜರುಪಡಿಸಿ ಬಂಗಾರಪೇಟೆ ತಾಲೂಕು ಗಟ್ಟುಕಾದ ಕಾಮದೇನಹಳ್ಳಿ ಮಂಡಲ ಪಂಚಾಯತಿ ಚುನಾವಣೆಯಲ್ಲಿ ಸ್ಪರ್ಧಿಸಿ ಸದಸ್ಯರಾಗಿ ಆಯ್ಕೆಯಾಗಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿ ಮೇಲ್ಮನವಿದಾರರು ರಾಜಕೀಯ ದುರುದ್ದೇಶದಿಂದ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಮೇಲ್ಮನವಿಯನ್ನು ವಜಾ ಮಾಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾಮೀಟರ್ ಮೇಲ್ಕಂಡ ಎದುರುದಾರರಾದ ಶ್ರೀ ಕೃಷ್ಣಪ್ಪನವರು ಹಾಜರುಪಡಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಸಮರ್ಥಿಸಿ ತಹಸೀಲ್ದಾರ್ ಬಂಗಾರಪೇಟೆ ತಾಲೂಕರವರು ಗ್ರಾಮ ಮಾಜರ್ ಸೂಚಿಸಿದಂತೆ ಎದುರುದಾರರು ನಾಯಕ ಜಾತಿಗೆ ಸೇರಿದವರು ಎಂಬುದಾಗಿ ದೃಢೀಕರಿಸಿರುವುದರಿಂದ ಮೇಲ್ಮನೆಯನ್ನು ಅಂಗೀಕರಿಸಲು ರಹ ಇಲ್ಲದ ಕಾರಣ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಿದೆ. The appeal filed by the complainants has been dismissed. My lord, in the year 2020, my lord, I have obtained a caste certificate. My lord, I have been continued as a president. My lord, subsequently there was a government notification of how to follow the procedure while determining the caste. Your lordship may kindly see the circular at annexure H, my lord.
Yes.
My lord, at page number 31, my lord, para 9. Based on the judgments of this honorable court and the Supreme Court, ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಹಲವಾರು ಆದೇಶ ತೀರ್ಪುಗಳಲ್ಲಿ ಸ್ವಹಿತಾಸಕ್ತಿಯಿಂದ ಸಂಘ ಸಂಸ್ಥೆಗಳಿಂದ ನೀಡಲಾಗಿರುವ ಜಾತಿ ಗುರುತಿನ ಪ್ರಮಾಣ ಪತ್ರ ಅಥವಾ ಯಾವುದೇ ಅಧಿಕೃತವಾದ
ಮಾಧುರಿ ಪಾಟೀಲ್ ಆಯ್ತು ಆಮೇಲೆ
my lord, the impugned order has been passed.
Where is the impugned order?
My lord, annexure A, my lord.
What does it say?
My lord, your lordship may kindly see para 12, my lord. Page 12, last paragraph. ದಿನಾಂಕ 11/7/2025 ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೋಲಾರ ಜಿಲ್ಲೆ ಅವರ ಪ್ರಕರಣ ವಿಚಾರಣೆಯಲ್ಲಿ ದೂರುದಾರರು ಹಾಜರಿದ್ದು ಎದುರುದಾರರು ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಚಿನ್ನೂರು ಅದ್ದನ್ನ ಅಲಿಯಾಸ್ ಅಪ್ಪಯ್ಯ ಶ್ರೀಮತಿ ಮುನಿಯಮ್ಮ ಬಿನ್ ಅಪ್ಪಯ್ಯ ಇವರು ಗೈರು ಹಾಜರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ತಹಸೀಲ್ದಾರ್ ಕೆಜಿಎಫ್ ರವರು ನೀಡಿರುವ ತಮ್ಮ ವರದಿಯಲ್ಲಿ ಸರ್ಕಾರಿ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಗೋಣಮಾಕನಹಳ್ಳಿ ಕೆಜಿಎಫ್ ಇಲ್ಲಿನ ಶಾಲಾ ದಾಖಲೆಗಳಲ್ಲಿ ನಾಯ್ಡು ಜನಾಂಗ ಸೇರಿದವರು ಸ್ಪಷ್ಟವಾಗಿದ್ದು ಮತ್ತು ಸರ್ಕಾರಿ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಕೆಜಿಎಫ್ ಇಲ್ಲಿ 1967-68 ಸಾಲಿನಲ್ಲಿ 8ರಿಂದ 9ನೇ ತರಗತಿಯಲ್ಲೂ ವ್ಯಾಸಂಗ ಮಾಡಿದ್ದು ಸದರಿ ಶಾಲಾ ದಾಖಲೆಗಳಲ್ಲಿಯೂ ಸಹ ನಾಯ್ಡು ಜಾತಿ ಎಂದು ನಮೂದಾಗಿರುವುದರಿಂದ ದಾಖಲೆಗಳಿಂದ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಪೋರ್ಷನ್ he has cancelled the caste certificate of the petitioner.
DCVC ಹೋಗಿಲ್ಲ.
Blood
DCVC ಹೋಗಿಲ್ಲ. Caste verification.
No, it is a caste verification committee only. There are committees. You lordship, you can see the page number 13.
This is DCVC.
Yes, my lord.
ಜಿಲ್ಲಾಧಿಕಾರಕ್ಕೆ ಹೋಗಲಾರ ಅಂತ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, but it is the verification committee.
Yes, my lord. My lord, I have not been served notice. My lord, the Tahsildar issued a notice. My lord, I have replied. I have furnished all the documents. You lordship, you kindly see the notice issued annexure E, my lord, page number 24.
He was not issued notice by DCVC. And AGA accepts notice for respondent number 1 to 5. Notice for respondent number 6 and 7 is deferred for now. And AGA is directed to secure instruction, make a submission as to whether notice was issued to the petitioner before the impugned order at Annexure A was passed.
I have sought for a stay order, my lord. Your lordship may kindly see the paper publication and Annexure H. Now, one day on note.
You have an appeal provision. Notice illa andre matra now interfere.
My lord, the appeal has been filed. It was decided that I am belongs to such a so caste. My lord, without verifying the order passed in the earlier 1994.
So ella ತಗೊಂಡು ಬಂದ್ಬಿಟ್ಟು ಹೈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಡಿ.
ಇಲ್ಲ ಇಲ್ಲಿ ನಾನು ಒಂದೇ ಒಂದು Annexure H J ಒಂದು ನೋಡ್ಬಿಡಿ.
You have an appeal provision. ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು appeal ಅಲ್ಲಿ ಇದು ಕನ್ಸಿಡರ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು. ನಿಮ್ಗೆ ಇವಾಗ ಸದ್ಯಕ್ಕೆ ನೋಟಿಸ್ ಇಲ್ಲ ಅಂದ್ರೆ
they are registering the criminal case.
We'll get that information. ಏನ್ ನಿಮ್ಗೆ ಇವತ್ತೇ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್
Your lordship may kindly see the Annexure J.
ಇವತ್ತೇ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಅಲ್ಲ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Respondents are restrained from initiating any criminal proceedings
Yes.
against the petitioner till the next date.
Please.
Relist on 25th October.
Publish.
1 of 25 is allowed.
Rajkumar MD.
Lordship, and for the petition, I am seeking for writ of mandamus, my lords. Lordship, I have given a requisition for installation of underground drainage system. I have already paid all the betterment charges, but they have not taken up any action, my lords.
BWS is where? Shri KV Monish Kumar is directed to accept notice for respondent 1 and 2, who is granted a week's time to obtain instruction, make a submission.
Any short date, my lords, because I've already set up a house, my lords. Toilet ಕೂಡ ಇದು ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ ಮನೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದೆ.
In number of matters, we are not able to handle that. So you wait for that. We list on 10th November.
Please.
46. Vipin Hegde.
Petitioners, my lord, 1 and 2 are husband and wife. Lord, there is a dispute between the family members of petitioner number 1. There are civil dispute, my lord, pending in the court. The sister of the petitioner number 1, my lord, has filed 2 cases against the petitioners. Sister of the petitioner number 1. My lord, in one case, my lord, this honorable court has stayed the proceedings in respect of offense under section 420.
Charge sheet ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ, cognizance ತಗೊಂಡಿಲ್ಲ. In the second case, my lord, B report has been filed. That has not been accepted. That is pending consideration.
Charge sheet ಆಗಿಲ್ಲ ಅಂದ್ರೆ full valid.
Technically ground here in this case. If your lordship could kindly see page 36. First complaint, my lord, is on page 36, crime 606. In crime 606, my lord, page 36, your lordship got page 36.
Yes.
Crime 606, Annexure K. Now, if your lordship will come to page 44, Annexure M. So far as 606 is concerned, B report is filed. Is my lord?
Yes.
Annexure M, page 44.
Is B report.
So far as both the petitioners are concerned, both the accused therein are concerned. So far as page 40, Annexure L, the
195.
195, crime 195. Accused therein are not the petitioner herein. If your lordship could kindly turn to the order sheet and page of order sheet of this one, report in page 50, Annexure N. Your lordship may kindly turn to 52, order dated 27/8/2024. So, insofar as crime 195 is concerned,
Stay of investigation.
where the petitioner, the technical ground, my lord, now, both of them would have to get the full validity pass.
Because there is a stay.
Yes, my lord.
Because there is a stay. Otherwise you would say there would have been a charge sheet filed.
Since B report is filed in one case and in other case that the other part is that, my lord, let them appear before the officer, passport officer, and submit all these documents. If already submitted also, my lord, let them go tomorrow, my lord, or day after tomorrow with the order copy, my lord. I'll inform them to give the passport at the earliest, my lord, because the contention is that, my lord, they need to travel.
And they need to travel tomorrow.
My lord, they are having a showroom called as Arnav Jewelry. They have exhibitions, my lord, lot of exhibitions. Her daughter is studying in Amsterdam, doing economics. My lord, and traveling on 28th of this month. I have produced the invite also.
28th and
28th.
ನಾಳೆ ಹೋಗಿ ಕೊಟ್ಬಿಡಿ.
And my lord, we have given, submitted, my lord, I have produced that annexure, my lord, the.
Mr. Hegde, you want them to delay it?
No, I will go, my lord, it is not, my lord, I will go tomorrow itself.
Mr.
Today itself we will
Bhushan
go.
has been, that is a submission.
Today itself will go.
Then go, and my lord, the other part is that, my lord, if not any other case of.
No, there is no other case, my lord. It is filed by my petitioner number 1's sister, the first.
Shri Shanti Bhushan has learned DSGI accepts notice for respondent number 1 and 2. Petitioner is before this court seeking for the following beliefs. Petition number 1 and 2 are husband and wife having 2 children and permanently residing in Bangalore, carrying on the business of jewelry designers. They had been each of them had been issued passports, as regard which they had submitted an application for renewal stroke reissuance. The same not having been done on the ground that there was a proceeding in crime number 195 of 2024, which had been filed. The petitioner had submitted detailed objections wherein they had informed the concerned authorities about the stay of the proceeding in crime number 195 of so and so.
So far as the first petitioner is concerned, my lord, he's got the passport already. On that, my lord, he did not inform the crime in the application therein when he was submitting it. Insofar as the second petitioner is concerned, my lord, the application is pending with the passport office, my lord. That
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅದು ಇಶ್ಯೂ ಆಗಿದೆ ಅಂತ?
ಅಲ್ಲ ಹೇಳಿದೀವಿ. Subsequently, my lord, para 7 ಅಲ್ಲಿ.
Para 7 ಅಲ್ಲಿ.
My lord,
passport so and
thereafter, the respondent number 2 issued a show call. The copy of the same, it is further submitted that due to exhaustion of pages of the said passport, the petitioner number 1 filed an application.
page for 34 annexure J, we have given notice, my lord.
It is stated that though a passport had been issued to petition number 1, having validity until 3/6/2029, due to exhaustion of pages in the said passport, petitioner had filed an application for issuance of a passport ಅದೂನು ಇಶ್ಯೂ ಆಯ್ತಾ?
ಅದು issue ಆಗಿದೆ. After issuance of the passport, they issued a show cause notice.
With additional pages which also came to be issued. Thereafter, respondent number 2 had issued a show cause notice dated 6/10/25 to petition number 1 calling upon to provide suitable explanation in respect of the police verification report received from Konankunte police station as regards registration of crime number 195 of 2024. The petitioner number 1 replied to the same on 12/10/2025. ಅದರಲ್ಲಿ ಹೇಳಿದ್ರಾ the stay ಆಗಿದೆ ಅಂತ?
Yes, my lord, I have stated, my lord. I have produced
Informing
annexure E, my lord.
about the stay of the said proceedings by this court in criminal petition number 8261 of 2024. In the meanwhile, petition number 2's passport.
And my lord, second crime number B report ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ವಿ.
And as ಅದು ಕೇಳೇ ಇರಲಿಲ್ವಲ್ಲ ಅವರು?
ಕೇಳಿಲ್ಲ, but we have also mentioned about that also.
Insofar as petition number 2 is concerned, the passport issued to petition number 2
It's not issued still.
Earlier issued.
It was issued wide.
Not as earlier issued, then we filed application for.
ಅವ್ರದ್ದು exhaustion, na?
Exhaustion, yes.
Was also issued a passport having validity until 3/6/2029. Due to exhaustion of pages of the said passport, petition number 2 had also filed an application for issuance of a passport, which was not so issued.
Not issued.
But a clarification had been sought for by respondents as regards the criminal cases pending against the petition number 2. Petition number 2 replied to the same on 12/10/2025 in a similar manner, indicating the stay of crime number 195 in criminal petition number 9261 of 2024 and the B report having been filed in crime number 606 of 2024. Despite the clarification having been issued, the no passport having been issued.
Annexure J has been passed, my lord.
Annexure
Annexure J, page 34, my lord.
No passport having been issued, but a letter dated 14/10/2025 calling upon the petitioners to submit details of clearing of the criminal cases.
Clearance of case, clear agila, so we cannot produce it.
A clearance of cases.
Yes.
The petitioner is before this court seeking for the aforesaid reliefs. Shri Vipin Hegde, learned counsel for the petitioner, would submit that the petitioners are unable to provide proof of clearance of the case inasmuch as a stay order has been granted by this court in crime number 195. However, insofar as crime number 606 is concerned, B report having been filed, the same amounts to clearance.
Pending
of the said
consideration.
case.
Cognizance has not been taken. The annexure.
Idರಲ್ಲಿ 195. 606 B report ಆಯ್ತು.
Not accept, it's pending consideration before the court.
B report has been filed.
And
which
no
is
cognizance
pending-
has been taken, my lord.
Which is pending acceptance by the concerned court. However, he submits that no cognizance has been taken in relation thereto.
Page 59, my lord, the order of this court, where they say, until and unless cognizance is taken, my lord, they cannot deny the passport.
That is the reason, my lord, I made that submission that crime is still pending.
In that view of the matter, from the material on record, it being cleared that insofar as crime number 606 of 2024 is concerned, a B report though filed is yet to be considered by the magistrate. Insofar as crime number 195, the same having been stayed before by this court, there is no charge sheet which has been filed against the petitioner, which is pending consideration in any of the matters. In that background, the petitioners cannot be deprived of their right to travel under Article 21 of the Constitution of India by the non-renewal or non-issuance of a passport by the respondent authorities. In the above background, I pass the following order. Writ petitions allowed. Respondents are directed to consider the application for renewal stroke reissuance of their respective passports without reference to first partly allowed. Certiorari is issued, Annexure D is quashed, certiorari is issued, Annexure J is quashed. The petitioners are directed to furnish all the documents pertaining to the above matter to respond number 2 within 2 days from today. Respond number 2 is directed to consider the documents, the orders, etc., which are furnished by the petitioners and pass necessary orders renewing stroke reissuing the passport of the petitioner 1 and 2 with full validity within a period of 1 week from the date of the petitioner filing their respective documents.
Applied.
Page 55, not just a minute.
25.
Page 55.
55.
Page 55.
Hmm.
Marriage is at
Okay, Irubarda.
page 55.
Destination wedding. Why you should not be that?
Learned friend is also invited.
So.
You should
They are
understand.
common. It's all common friends, my lord.
You should understand. Has the invitation been given? See to it. Mandamus.
Yes.
I 1 of 25 is allowed.
47. Mallikarjun Reddy.
Yes, Mr. Reddy.
My lord, petition by the institution, my lord.
Refusal,
Allah, the recommendation, my lord, has been rejected. The fact.
Refusal, rejection. And AGA for respond number 2 issue notice to respond number 1 written up by 26th November.
Forty-eight. Venkatesh Sarbati.
Appeared for respondent, where is the petitioner? Mr. Arbatti.
I'm not aware. my
Filed
lord.
your objections?
Please, ma'am.
Pass over.
49.
Yes.
This is a matter, my lords, that pertains to release of subsidies. My lords, what has happened, my lords, in 2020, a sanction order was issued, my lords, for setting up manufacturing units for fish seeds. My lords, there, my lords, a condition was stipulated saying 40% would be given back to me once I complete the manufacturing unit, a rebate of 40%. My lords, thereafter, I submit the bills. The bills, my lords, are over 1.6 crores. My lords, once I submit the bills,
Notice agide.
my lords, the sanction order was issued on the Blue Revolution scheme.
So when will you file it? And AGA seeks for and is granted 2 weeks time finally to file a statement of objection. Objections, if any, by 31st, failing which will be taken as not filed, matter proceeded with, relist on 11th November.
Grateful.
Serial number 50, Arjun. 51. Gopal Singh.
Lordship, this petition is for seeking direction in nature of writ of mandamus. The petitioner is a partnership firm in the name of Amol Enterprises. My lords, on 27/2/2024, the petitioner is granted registration
He
certificate.
frees the bank account.
Yes, my lordship.
Notice has been ordered? No. ICICI?
Yes, my lordship.
Francis Xavier.
Francis
Lordship-
Xavier for respond number 1 and 2. Notice for respond number 3 is deferred for now. Relist on 25th October.
Please.
52.
Petitions.
Saptakiya.
It's pertaining to payment of stamp duty, my lords. Annexure is under challenge. My lord, what has happened, my lord, total 50 acres of the land. Annexure B, page 31, my lord, on 1992, I purchased, my lord, 40 acres. Remaining 10 acres, my lord, I wanted to purchase, my lord, the vendors came forward to release.
Interim order is
Interim order
Readings
for
ಆಗಿದೆಯಾ? You want to file objection or you want to argue? ಯಾವ file ಮಾಡ್ತೀರಾ? Council and AGA seeks for and is granted 2 weeks time finally to file a statement of objection. Objection, if any, by 31st October, failing which will be taken as not filed, matter proceeded with. Relist on 10th November.
Request for interim order to extend.
Interim order earlier granted is extended next week.
Apply.
53. M.R. Balakrishna.
And defreezing,
Freezing of bank account, madam.
ಯಾರು ಬ್ಯಾಂಕ್ ಯಾರು?
Lord Vinay Bhatt, madam.
ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ
State Bank of India.
ಯಾರು? ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಯಾರಪ್ಪ?
Francis Xavier.
ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾಗೆ. Francis Xavier for respond number 1, notice to respond number 2 is deferred for now. Relist on 25th October
Bless.
at 2:30 p.m.
Nagendra Nayak.
Mr. Naik. Interim order ಏನಾಗಿದೆಯಾ? Pass over.
55, Arjun. 56. Vaishnavi Nayak.
Pass
I
over.
agree for the petitioner, my lord.
Yes, madam.
My lord, I have filed this petition seeking issuance of NOC by the respondent for the debt that I've already cleared more than 20 years ago. I had availed a loan from the
Please, standing
respondent.
counsel for IDBI.
I'm not aware, Your Honor.
M.G. Kumar.
Shri M.G. Kumar is directed to accept notice for respondent. Counsel for the petitioner served 2 sets of the petition along with annexes on said counsel. Released on 13th November.
My lord, I have also filed IA for dispensation. Kindly, it may be allowed, my lord.
There is no IA put up today, madam.
I
57,
57. Freezing. You don't know. How many of this? And AG accepts notice for respond number 1. ICICI.
Francis Xavier,
Francis Xavier for 3. HDFC.
same.
Francis Xavier for respond number 3 and 4. Issue emergent notice to respond number 2 returned by 25th October. Counsel for the petitioner is also permitted to take out and summons in respect of respond number 2 returned by the same date.
58, yes, Ravikumar, party person.
I have filed a appeal before the respondent number 1 against respondent number 2. There is a reluctance on the part of the respondent 1 to complete the inquiry. I have filed several, though appeal was filed back in 2015, I had filed a writ before this honorable court, which is at annexure.
So it's not being disposed.
Yes. And moreover, at annexure.
Bar Council of India you have filed.
Sorry?
You have filed it before the Bar Council of India.
Yes.
Not before KSBC.
It was filed before that. It was rejected.
96. No order is taken. Yes.
At annexure E.
Ms. Anubha Srivatsava is directed to accept notice for respond number 1. Issue notice to respond number 2 returnable by.
Hand summons ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ ಇದು R1.
By 19th November. Counsel for the petitioner is also permitted to take out hand summons in respect to respond number 2.
1. Respondent number 1.
1 already notice ಆಯ್ತು. 2 hand summons ತಗೊಂತೀರಾ?
ಇಲ್ಲ 2 ಗಲ್ಲ. 1 ಗಿನ್ನು ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಸರ್.
Standing counsel service ಮಾಡಿ.
59, yes, Shivramu.
I appear for petition. The petitioner, my lord, are the card orders attached to the first respondent shop, your lordship. A suspension or based on their complaint, my lord, a statement was recorded and inspection was conducted, my lord. An order came to pass suspending the authorization of the first respondent. Then, my lord, he challenged the said order before the appellate authority, that is the deputy commissioner, second respondent herein, my lord. Before the second respondent, we filed an impleading application, my lord. The said application, my lord, without considering the said application, my lord, even there is no whisper regarding the filing of the application itself, my lord. Order came to be revoked, your lordship, by the deputy commissioner.
Yes.
Annexure H, your lordship, may kindly see annex page 6.
Notice ಆಗಿದೆ.
And allowed to.
And AGA accepts notice for respond number 2 to 4.
Yes.
Notice to respond number 1 is deferred for now. ಕೊಡ್ಲೇಬೇಕಲ್ಲ ಅವರು.
ಕೊಡ್ಲೇಬೇಕಾಗುತ್ತೆ.
Issue notice to respond number 1 written over by 19th.
Not for interim stay, my lord, because there is a severe allegations, your lordship, it was there, your lordship.
19.
Please.
60, Sandhya Yu Prabhu.
Authorized officer.
Lord, in this case, my lord, the last occasion, my lord, I was asked, my lord, to come with a figure, how much I'm ready to deposit.
ನಮ್ಮ ಮುಂದೆ ಏನಕ್ಕೆ ಬಂದಿದೆ ಇದು? ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಲ್ಲ. We have no jurisdiction. Matter relates to surface.
Surface initiate, ಅಂದ್ರೆ 13-2 ಕೊಟ್ಟಿದ್ದಾರೆ, 13-4 ಮಾಡಬಾರ್ದು.
And we have already considered the representation, therefore the matter is infructuous.
Lord, what I have requested is, my lord, they have not disposed it, my lord, they have given a reply, that's all, my lord. Well, what I have requested with the bank is to not to publish.
13-2 notice has been issued. So under which act has it been issued?
Surfacing.
We have no jurisdiction to pass any order. The subject matter of the petition is a issuance of notice under subsection 2 of section 13 of the Surface Act. Registrar Judicial is directed to look into the same and place it before the appropriate bench.
Interim order may be extended.
Interim order earlier granted is extended till next day.
Greatly.
We can't fix for the other bench.
My lords, my apologize, my lords, I appear in item number 57 due to technical difficulty. I couldn't log in, my lords. 57.
57 ಏನ ಮಾಹಿತಿ?
Sir, 25 and free, defreeze sir.
Defreeze.
25th.
My lords, highly obliged.
61. ST Vasant Kumar.
I'm the petitioner in this case, my lord. Facts of the case, my lord.
Certiorari and no interim
please, ma'am.
relief.
The respondent has issued an
AGA
endorsement.
accepts notice for respond number 1 to 4. ZP Bangalore South Devraj.
Devraj.
MS Devraj for respond number 5.
Similar,
Relist on
similar matter last week has disposed of this matter, my lord. Link page number
notice
7.
ಆದ್ಮೇಲಪ್ಪ disposal. First ಇವತ್ತು notice. Serve it on them. Relist on 13th November. A1 or 25 is allowed.
62.
For the petition and my lord.
CP noted.
Surface Act, my lord, section
Surface
13. Please, possession notice has been issued.
Matter relates to proceeding on Surface Act. Registrar Judicial is direct look into the matter and place it before the appropriate bench at the earliest.
Please.
63. Jeevan K.
For the petition. Really, we are the adjacent owners of the property belonging to the respond number 1, my lord. ನಮ್ಮ ಪ್ರಾಪರ್ಟಿಗೆ ಅವರ ಪ್ರಾಪರ್ಟಿಯಿಂದ ಬಂದಂತ ಈ ರೈನ್ ವಾಟರ್ಸ್ ಫ್ಲೋಟ್ ಇಂಟು ದಿ ಅವರ್
KPTCL
HV Devraju.
HV Devraju for respond number 1. Pawan Kumar for respond number 2. Council to submit furnish 2 sets of petition. Relist on 13th November.
Yes.
64.
For the petitioner, my lord.
Yes.
My lord, show cause notice. My lord, notice, impugn notice is at annexure A.
You are ready? You said Range andre VC anta. You are
My lord,
ready?
in fact,
Kodi.
is very short point, my lord. In fact, the impugned notice at page 39 is issued based on a show cause notice which was previously issued dated 25/2/2020, my lord. That show cause notice already stands quashed by this honorable court. Now, my lord, under rule 4(1) of the FEMA.
Some other matter had come like
Please,
this.
my lord, please, similar
Same,
matter.
you had appeared in this.
That quashing orders at page
Petitioner is before
161.
this court seeking for the following reliefs. The show cause notice, impugned show cause notice under annexure A has been issued in person of earlier show cause notice number T4 SRO SDE BGZO01/2020 dated 25/2/2020, page 40. The said show cause notice had been quashed by a coordinate bench of this court by the order dated 6th December 2024 in WP number 1418 of 2021. In that view of the matter, a show cause notice could not have been issued under a show cause notice which had already been quashed. As such, I pass the following order. Writ petition is allowed. Certiorari is issued, so and so at annexure A is quashed. IA 125 is allowed.
Grateful, my lord.
Surface in 65. The above matter relates to the proceeding and Surface Act. Registrar Judicial is direct place the matter before the appropriate roster. Mr. Sarvanan, ಇಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರೆ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೋದು.
And with my lord's permission, this was a matter filed as GM CPC, but we were informed that it will come under GM AC, accident claim.
Accidentally.
The case is listed before the trial court on 25th, my lord.
You are the insurance company.
I am for the accused driver, actually, my lord. An IA for rectification of an error in the deposition was rejected on the ground that the court has no jurisdiction. I have challenged that IA. Case is posted for final arguments on 25th. If this could be taken up on tomorrow or 23rd, my lord.
23rd.
23rd. I'm grateful.
Serial number 46. My request for the order, my lord, because day after tomorrow is a Saturday and passport office will be.
It will get uploaded.
Great.
46 hand delivery.
20 next week.
Huh?
Serial number 20.
20? ಏನಾಯ್ತು 20?
ಬೆಳಗ್ಗೆ ಸ್ವಲ್ಪ
Passover ಆಯ್ತು. ನೀವು ಯಾರಿಗೆ ಪೆಟಿಷನರ್ಗ ರೆಸ್ಪಾಂಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಏನು ಸ್ಟೇ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಿಲ್ವಲ್ಲ?
ಏನಿಲ್ಲ.
20 at the request of the counsel for the petitioner released on 12th November. Now locus standi has gone there.
17 is, it has to be likely to be listed, Maharaj.
48, learned counsel for the petitioner submits that the respond number 2 submits that insofar as the issue as regards locus of the locaicta, the same is pending consideration by the Honorable Apex Court in SLP number so and so. Release the above matter after disposal of SLP number so and so. Liberty is reserved to the petitioner counsels to mention the matter.
Court of 79 ಇದೆಯಾ ಏನು ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ ನೋಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 79. ಹಾ
71 ಚೆಕ್ ಮಾಡಿ.
79 ಅರ್ಜೆಂಟ್ನಾ?
75 ನೋಡಿ ಸರ್.
ನವೆಂಬರ್ ಡೇಟ್ ಹೇಳಿದಾರಾ? ಡೇಟ್ ಯಾವುದು? 2.
ಸೊ 75 ಆಯ್ತು 75 ಇದೆ.
ಸರ್ 71 ನೋಡಿ ಒಂದ್ಸಲ ಇದೆಯಾ?
Court officer, sir. Court officer, sir. ಮೇಡಮ್ ಇದು ಆಫ್ಟರ್ ಲಂಚ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೋ ಅಥವಾ ಲಿಸ್ಟ್ 230
ಮ್ಯಾಟರ್ಸ್ ಅದಾದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಆಮೇಲೆ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ 230 ಮ್ಯಾಟರ್ಸ್ ಅದಾದ್ಮೇಲೆ ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಓ ಓಕೆ ಓಕೆ ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು.
ಅದೇ ಅವರು ಅನುಭಾ ಶ್ರೀವಸ್ತವ ಅಂತ ಇದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರೆ ರೆಗ್ಯುಲರ್ ಆಗಿ. ನನಗಲ್ಲ ನಾನ್ ಆ ಕೆಲಸ ಬೇರೆ ಮಾಡ್ಬೇಕಾ? ನನಗೂ ಗೊತ್ತಿಲ್ಲ, ಇಲ್ಲಿ ಬಂದು ಗೊತ್ತಷ್ಟೇ. ಅವರು ಅಸೋಸಿಯೇಷನ್ ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ಫೋನ್ ನಂಬರ್ ತಗೊಂಡು ಅವರು ಅನುಭಾ ಶ್ರೀವಸ್ತವ BHA ಅಲ್ಲಿ ಕೇಳಿ ಫೋನ್ ನಂಬರ್ ಕೊಡ್ತಾರೆ. ಇಲ್ಲ ಈಗ ಕೊಡಲ್ಲ, ಇನ್ನೂ ಇದೆಯಲ್ಲ. ಇಲ್ಲ 79 ಇದೆ ಇದೆ. ಯಾರು ಅವರ
ಮೇಡಮ್
79 ಅರ್ಜೆಂಟ್ ಆಯ್ತೇನಪ್ಪ? ಯಾವಾಗ? ಇಲ್ಲ 78 ಅದು.
ಮೇಡಮ್ ಮೇಡಮ್
ಅಲ್ಲಿ ಕೇಳಿ ಬ್ರಾಂಚ್ ಯಾಕಾಗಿಲ್ಲ
ಮೇಡಮ್ 75 ಒಂದು ನಮ್ಮ ಎದುರುಗಡೆ ನಮ್ಮ ಫ್ರೆಂಡ್ ಇದ್ರು ಇಲ್ಲಿ. ನಾನು ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಕ್ ಹೋದೆ, ಲೇಟ್ ಆಗೋಯ್ತು. ಒಂದ್ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಸರ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂದ್ರು. ನಾನು ಒಂದ್ 2 ವಾರ ಟೈಮ್
ಹಾಸ್ಟೆಲ್ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ 4, 5, 6 ಇಂತ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಸಾಕಲ್ವಾ?
2:30 ಇಲ್ಲ ಕೇಳ್ಬಿಡ್ಲಾ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಟೇಕಿಂಗ್ ಚಾನ್ಸ್?
ಕೇಳ್ಬೋದು, ಹಂಗೂ ಕೇಳ್ಬಿಟ್ಟು.
ಆಯ್ತು ಬೆಸ್ಟ್.
ಇಲ್ಲ ಮೆಮೊ ತಗೊಳ್ಳಲ್ಲ. ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಮಾಡ್ರು, ಅಲ್ಲ ಇವಾಗ್ಲೇ ನೀವು ಬರೋದೇ 2:30 ಅಲ್ವಾ? ಕೊಯ್ಲೆ ಹೋಗ್ಬಿಡುತ್ತೆ. ಅದರ್ ಸೈಡ್ ಅವರು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಬಿಟ್ಟು ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ಇಲ್ಲಿ ಅವ್ರಿಗೆ ಬರೋದು ಲೇಟ್ ಆಗುತ್ತೆ. ನೀವು ಕೊಟ್ರೆ ಬೇಗ ಆಗಲ್ಲ, ಅವ್ರು ರೆಡಿ ಇರ್ತಾರೆ. ಇದೇನ್ ಸರ್ ಇದು? ನೀವಿದ್ದೀರಾ? ನನ್ನ ಹತ್ರ ಕೊಡ್ಲಿಲ್ಲ, ಯಾವ್ದೋ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಕೊಟ್ಟಿರ್ತೀರಾ. ನಾ ಇಲ್ಲೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಡ್ತಾ ಇರ್ತೀನಿ. ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಮಾಡ್ತೀನಿ. ಸರ್ ಮಾಡಿಸ್ತೀನಿ. 50 ಪಾಸ ಫೈಲ್ ಬೇಕಾ? ಪಾಸ ಅವರೇ ಅಲ್ಲ, ಇಲ್ಲಿ ಕೇಸ್ ಡಿಸ್ಪೋಸಲ್ ತೋರಿಸಿದ್ದಾರೆ. ತೋರ್ಸಿದ್ರೇನೆ ನಾವು ಅಪಿಯರೆನ್ಸ್, ಈಗ ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆದ್ರು ಅಂತ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಬರಿಬೇಕಲ್ವಾ? ಕೈಯಲ್ಲಿ ಬರೆಯಂಗಿಲ್ಲ ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ. ಟೈಪ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಟೆಂಪ್ಲೇಟ್ ಜನರೇಟ್ ಮಾಡ್ಕೋಬೇಕು. ಆ ಟೆಂಪ್ಲೇಟ್ಸ್ ಬರ್ಬೇಕು ಅಂದ್ರೆ ನಾವು ಡಿಸ್ಪೋಸಲ್ ತೋರಿಸ್ಬೇಕು. ಮಾಡಿರ್ತಾರೆ. ಆಗಿದೆ ನೀವು ಮಾಡಿ. ಆಯ್ತು ನೋಡೇ ಬಿಡ್ತೀನಿ ಒಂದ್ಸತಿ ಇರಿ. ಆಗಿದ್ಯೋ ಇಲ್ವೋ ನೋಡೇ ಬಿಡೋಣ. ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡ್ಬಿಟ್ಟೆ ಹೋಗೋಣ. ಮಾಡಿರ್ತಾರೆ ಅಲ್ಲಲ್ಲೇ ಮಾಡ್ತಿರ್ತಾರೆ. ಇಲ್ಲಾಂದ್ರೆ ಫೈಲ್ ಬೇಕು ಅಂತ ಅವ್ರು ಕೇಳ್ತಾರಲ್ಲ, ಫೈಲ್ ಕಳಿಸ್ಬೇಕು ಅಂದ್ರೆ ನಾವು ಅದನ್ನ ಜನರೇಟ್ ಮಾಡಿ ಪ್ರಿಂಟ್ ಆಗಿ ಕಳಿಸ್ಬೇಕು. ಇಲ್ಲ ಪೆಂಡಿಂಗ್ ಮಾಡ್ಬಿಡ್ಲಾ? ಅಲೋಡ್ ಅಂದ್ರಲ್ವಾ? ಇದು ನೆಟ್ವರ್ಕ್ ಎಲ್ಲ ತುಂಬಾ ಸ್ಲೋ, ತುಂಬಾ ಟೈಮ್ ತಗೊಳುತ್ತೆ ಮಾತ್ರ. ಇದು ನೆಟ್ವರ್ಕ್ ಅಲ್ಲೇ ವರ್ಕ್ ಆಗೋದು, ಹಂಗಾಗಿ ತುಂಬಾ ಟೈಮ್ ತಗೊಳುತ್ತೆ. ಅವ್ರಿಗೆ ಬೇಕಾದಷ್ಟು ರಿಸರ್ವ್ ಮಾಡಿದೆ, ಏಪ್ರಿಲ್ದೆಲ್ಲ ಇದೆ. ಏನ್ ಮಾಡ್ತೀರಾ? ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಯಾವಾಗ? ಇಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ, ಅದೇ ಹೇಳೋದು. ಒಂದ್ಸತಿ ಮಾಡಿ ಸಬ್ಮಿಷನ್. ನೋಡಿ ಇದೆಲ್ಲ ತೋರಿಸಿದ್ದೀನಿ. ಆಯ್ತು ಆಗಿದೆ. First Kalburgi bench matters, then second list, then 230 matters in first list, then passed over, then list will be continued. ಇದು ಲಿಸ್ಟು ವಾಪಸ್ ಕೊಡ್ಬೋದು ನೋಡಿ. ಟಿಕ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಕೊಟ್ರು, ಆಮೇಲೆ ಬೇರೆ ಸರ್ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ, ಸೆಕೆಂಡ್ ಪೇಜ್ ಅಲ್ಲಿ ಇತ್ತು. ಇಲ್ಲೆಲ್ಲ ಸಣ್ಣ ಇದೆಯಲ್ಲ, ಇದೆಲ್ಲ ಆಮೇಲೆ ಯೂಸ್ ಮಾಡಿರೋದು. ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಏನು ಮಾಡ್ತಿರ್ಲಿಲ್ಲ, ಒಳಗಡೆ ನಾವಂತೂ ಬರೋದೇ ಇಲ್ಲ. ನಾನು ಆಫೀಸ್ಗೆ ಬರಲ್ಲ ಅಷ್ಟರಲ್ಲಿ. ಇಲ್ಲಿ ಬಂದ ತಕ್ಷಣ ಈಗ ಮುತ್ಕೋತಾರೆ, ಹೋಗಿ ನೋಡೋಣ ಅಂದ್ರು ನೋಡಕ್ಕೂ ಟೈಮ್ ಕೊಡಲ್ಲ. ಹೇಳಿ. ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಮ್ಯಾಟರ್ಸ್, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟು, ಆಮೇಲೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರೋ 230, ಅದಾದ್ಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಆಮೇಲೆ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ. ಇಲ್ಲ 4 ಗಂಟೆ ಆದ್ಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ. ಡೌಟೇ ಆಗಲ್ಲ ನನ್ನ ಪ್ರಕಾರ. 2:30 ಟೈಮ್ ತಗೊಂಡ್ಬಿಡಿ. ಅದೇ ಅದಕ್ಕೆ ಗೊತ್ತಿಲ್ಲ. ಬರ್ತಾರೆ, ಯೂಶಲ್ ಆಗಿ ಬರ್ತಾರೆ. ನೀವು ಲೇಡೀಸ್ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಮಧ್ಯಾಹ್ನ. ಇಲ್ಲ ಇದು ಫಸ್ಟ್ ಲಿಸ್ಟ್, ಇದು ಕಲಬುರ್ಗಿನ, ಇದು ಈ ತರ ನಂಬರ್ ಇದೆ ಅಲ್ಲ, ಇದೇನೋ ಇಟ್ರಿ ನೋಡಿ. ಇಲ್ಲ ಫಸ್ಟ್ ಕಲಬುರ್ಗಿಗೆ ಹೋಗ್ತೀವಿ. ಆಮೇಲೆ ಹೇಳಿ ಮೇಡಮ್.
Ma'am, will the list continue after 2:30?
No. First Kalburgi bench matters, then second list, then 230 matters in first list, Then past overs, last, continue.
Okay, so the item number 72 will come towards end of the board if I'm not wrong.
Yes, ma'am, after 4 o'clock.
Okay, thank you, ma'am.
ಅದೇ ಈಗ ಹೇಳಿದ್ನಲ್ಲ ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಆಮೇಲೆ
Listed today. It has not come today. Listed today. It was given, it has not been listed. Tomorrow. Tomorrow we have CMPs. No, I know, that's what the court officer said. Problem is this, my lord. There is no interim order. The trial court is insisting that I have to proceed with the arguments, etc. and all that. A very short legal question is involved. When is the matter? It is there on 23rd. 23rd will take it.
With your lordship, serial number 87.
AC7.
87. My lord, the respondent 4-5 counsel, without informing me, have taken a 1 month time. The matter is extremely urgent. Is that, my lord, teacher's salary has to be paid. The bank unnecessarily freeze the account of the management. No. Before that, not called.
We asked you,
No,
have you informed?
No.
If you are not informed, you can't take a judgment like
this. I told, my lord, your last my kindly.
That information with information ಮಾಡಿದ್ರೆ ಅವ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕು.
ಖಂಡಿತ ನನಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ.
27 we won't. It's not.
23rd your last may have it.
23rd it's unlikely to reach.
ಅಲ್ಲ 24th my lord. ಏನಂದ್ರೆ ಸ್ಯಾಲರಿ ಕೂಡ ಕಷ್ಟ.
24th ಆಗಲ್ಲ. 25th try ಮಾಡಿ. 87 25th.
Kindly you'll ask for the 25th.
My lordship, my lord, fresh matter, my lord,
87 ಬೆಳಗ್ಗೆ ಇದೆ order. ಅದನ್ನ relist at the request of counsel for respondent number 4 and 5 relist on 25th.
Kindly, your lord, fresh matter, my lord, scrutiny has done, my lord, but I have not. Tender is
Can't
last
take
date
it
is.
up, but now at 2:30.
Last date is the 21st, your lord.
We can't
Scrutiny
take it up
has
now.
done, my lord, only because
Why
of the
did you
memo.
wait till, sorry.
Kindly, your lordship.
ಶುರು ಮಾಡಿ.
Kalburgi bench matter. Harshavardhan Malipatil.
Yes, madam.
Compliance report is awaited, my lords. May I seek for 3 weeks accommodation, my lords, because
3 weeks, not 3 weeks.
Because my lords, there is a delay in communication, my lords, and 3 departments have to work out regarding the compliance.
SCGP submits that given 4 weeks time, compliance would be reported,
Yes.
released on 26th November.
Oh, bless.
List number 2. Serial number 1. Jairaj GS.
There is one. R3 is still not served. Your opinion in which matter, Mr. Male?
Lord, I am the petitioner, my lord, in WP number 23601, my lord.
Rahmatullah Kotwal submitted at